Colleagues, good morning everyone. I hope you are all rested, and can we sincerely apologize for the delay. According to our program, we are expecting the Deputy Minister to come through, but he has delayed in traffic, but he will be joining us very shortly. So we will be continuing with the program so long. Today's program is looking at issues related to traditional authorities and the constituencies that they represent. And we want to hear from them in relation to what are their views about the land issue in relation to the Native Land Act of 1913, and what is it that they are thinking about when we are looking at Section 25 in the Constitution. Yesterday, a lot of debates started to emerge towards the end of the day, and there was a question that was posed from the floor in terms of when do we get our land back? So it will be interesting to hear their views today and their contributions and what they think we should be doing in relation to resolving this issue. So when we look at our program, colleagues, we have traditional authorities who will be coming through to take us through their insights and also the recommendations that they would like to put forward. But we would like to sincerely apologize because the first person who's supposed to speak on the program, who is the Deputy Minister, Prince Solile Ncamashe, he has delayed a little bit in traffic, but he will be joining us very soon. So there will just be that adjustment in the program. So we would like to start with the speakers who are here. And I would like to call up on the stage HRH Zolile Mkiva, who's an MP, a Member of Parliament. And he is part of the Congress of Traditional Leaders of South Africa. Nkosi Zolile, if you can come up and join us on the stage. We also have Ms. Zamantu Ngwambeki, who is the Gauteng Provincial Manager for the South African Human Rights Commission, if she can also join us on stage. And we have Professor Nomthandazo Ntlama, who is part of the University of Fort Hare. She'll also be joining us on stage, if you can come through. This session will be moderated by our Commissioner, Angie Magwetla. She is already on stage. Please let us also bear to the fact that Commissioner is on stage. She's on a wheelchair, so we have put her on this side so that she can be visible as well to our audience. Ladies and gentlemen, let me hand over this session without wasting any further time so that we can get along with our discussions. Thank you so much, Commissioner Angie. It's over to you.
Thank you. I'd like to welcome you today to the second day of deliberations of the conference. Using the words of one of us presenters yesterday, to develop real policies, we need to discuss the cause of the problem. And I believe that at yesterday's session, the various issues surrounding the land reform, from the continuous impact of apartheid, the prices of land, the lack of willing buyers and sellers, gender equalities, lack of adequate policies to interpret to Section 25 of the Constitution, and lack of infrastructure were properly ventilated. Beyond ventilating the issues, various recommendations were made to the Commission as it takes this issue further. So the panel I will be presenting today is with traditional councils and traditional leaders. So our panel members have already been introduced, and we'll start with His Royal Highness Zorani Mkiva, who is an MP he's a MP of Contra Lesser. Yes. So over to you, Mr. Mkiva.
Good morning, everyone. Molweni. Nilele kakuhle? Elizweni lo tatomkhulu. No makhulu. Let me introduce myself. Zolani Mkiva. I am the General Secretary of the Congress of Traditional Leaders of South Africa, iContrales. I also represent the ANC as a Member of Parliament. I'm here to speak in my capacity as the General Secretary. And I'm just going to speak at a very high level without theorizing much, because I think the over-theoretization about the land question has given all sorts of problems to us. The example to that is that there are a myriad of pieces of legislation that talk about land in the country right now, which I believe creates a confusion that leads to the stagnance that we see insofar as land reform in the country. So let me start from the beginning. Commissioners of the Human Rights Commission, all the leadership in the House, thank you for inviting us to come and make our input here, and we're looking forward to working closely with the Human Rights Commission going forward. But let me start from the beginning by saying the wars of resistance and wars of dispossession were fought under the stewardship of traditional leadership in the country. They were in the front line. Many of them were beheaded, many of them were killed, many of them were banished in islands, and some of them imprisoned. Some of them, their skulls, by the way, are still sitting somewhere in Europe as trophies, which symbolizes victory over us as the African people in this part of the continent. And these wars were being fought in defense of our land. In other words, we went to war to fight to protect our land. So you know that this began in the Western Cape and it went throughout the country. So the first victims of land dispossession is the Africans who were based and located in the mouth of Cape Town. That's why the Western Cape is still not liberated, technically speaking. Now, dispossession was undertaken through genocidal means. In other words, hundreds of thousands of our people were killed mercilessly in order for our land to be taken away from us. It's important that I say this, because if you hear when the speakers speak here yesterday, they emphasize the history of recency, and then they overlook that important aspect which actually ushered the birth of the liberation movements in our country. So even the ANC itself is born out of the struggles which were waged by the institution of traditional leadership. That is why at its birth there was an upper house in the ANC which was called the House of Chiefs. Then the politicians manipulated and did everything to do away with that house so that they can employ what I call the Western ideologies of administering affairs of the nation. But the good thing is that Contralesa is there to fill that void and that vacuum, so that at all material times we can always mainstream the importance of the institution of traditional leadership in managing the national question. So the Native Land Act of 1913, after we have been defeated or conquered by people of European origin, they then, out of their government, which was a colonial government, illegitimate, illegal, brutal, they then came up with all the laws, but this law in particular, the Native Land Act, is a culmination of the institutionalization of land dispossession. And I think if colleagues, we are to look at it in that way, so that we don't come here in the podium and speak a jargon and say it was the legalization and therefore it is equal to legal. We take a view that it was an institutionalization of a genocidal land dispossession. The act itself, therefore, cannot be looked at as though it was legal and legitimate in the eyes of the people. Furthermore, the colonial state transformed in later years to become an apartheid state, which was then also declared by the United Nations as a crime against humanity. Which means that the regime itself, with all its instruments and protocols, constitute criminality. That is why when we were fighting for our liberation, we say the first thing that we'll do, once we achieve a stage wherein we're saying we are getting into the new dispensation, we will repeal, underline, repeal, all the apartheid laws and colonial laws. So I often say, as a leader of Contralesa, informed by the policy of the collective as well as Contralesa as a progressive formation, which is a motive force in South Africa, that we made a strategic blunder by when we were writing and crafting the new constitution of the new South Africa, of actually inheriting some pieces of legislation from the colonial order and the apartheid order and make them part of a new constitution of a democratic state. It's a strategic blunder because you begin to authenticate legal framework which was thought of by people who did not take you into account as the African majority when they were making laws that were to govern a population which you are a majority in. Our view, therefore, as Contralesa has always been that we should have repealed all those laws and actually make a constitution that is embedded on the African laws. The strategic blunder about this one that we have is that it is even embedded in European laws, which are colonial, imperial, and are entrenching the subjugation of the African majority. Now, when you amend laws that were brutal against you, you can't do justice. Because if you were to do the audit on the laws of the new constitution, you find that it is an amendment of something that was actually, proclaimed during the colonial era or the apartheid era. And that's why you will always have issues of suffocation for our people. So what we are calling for, therefore, as Contralesa is that we need to restore all the land and place it under the stewardship of the state, and then look at the land reform and restitution from that perspective. Because if you say you are going to do it in a piecemeal fashion, it is going to take another 2,000 years, if it will ever happen. Because you are saying, in essence, the people that were able to get land through illegal, illegitimate, and brutal and genocidal means, they must keep it. It's legal now. We, as the New South Africa, we are saying, yes, you got it from your parents or your great-grandparents, keep it, but when we want to expropriate, we will negotiate with you. Or when we want to buy, we will negotiate with you. It's not right. Let me make an example. The New South Africa, from this perspective that I've just outlined to you, has benefited those that were historically advantaged more than those that were historically disadvantaged, purely because of those systematics. So even on the land question, because they were advantaged by coloniality, by apartheid, they got property, assets, and everything. And then the new government says that we recognize that those assets, they got them illegitimate, but we are legitimizing them to keep them, and we will then buy them from them in order to make justice for those who are marginalized. It's a foregone conclusion. It's not going to happen. We're going to revolve, in a little space, and we are going to be making zero moves when it comes to this land question. Now, someone was saying yesterday, for instance, the statistics, correct or incorrect, accurate or inaccurate, but I think they sit at that level, that 72% of land owned in South Africa sits in the hands of white people. Let me put it this way. That land actually sits with people of European origin. I think we have to speak the truth. It displaces people of African origins who are aborigines here. And they are reduced to less than 10% of land, and they are more than 70%, and they only have 10%. And people of European origin are holding 72% of land, and they are less than 15% of the population. It's a very, very bad picture. And it's a recipe for a disaster. And I'm saying it's a recipe for a disaster because we, as this generation, we may tolerate this, but making an example with myself, all my children will never accept this. And I think that if we don't resolve this, then it is going to call for another revolution. It's inevitable. There's going to be another revolution in South Africa if the land question is going to remain being addressed in a piecemeal fashion. The second point that I'm making then, because we are saying restore it back to the state, so that the state can say all land in the country is now under the stewardship of the state. Then you change the tenureship system. You give other people leases and so on and so forth. But the total ownership of the land, put it under the state so that you can then do justice in terms of land reform. You can't do land reform with land that does not sit with you as the state. You can't plan about something that is not under your hand. It's impossible. In fact, when you look in the South African Republic, which was established by colonialists, you'll find that the state is more like an estate agent that has got an oversight over property that is owned by property owners. You see this dynamic where the state is reduced into a state of being an agent that must employ policies of appeasement in order to be negotiating for its citizens to get what it thinks is entitled to. A very difficult arrangement. So restore the land back to the state, and then you are able to then employ restitution and land reform. And we are saying unapologetically that the custodianship of land in South Africa, all of it, when all is said and done, must be placed under the institution of traditional leadership. Because governments come and go. You don't want a situation where a particular government that upholds a particular ideology is going to interfere with land in a manner that follows a particular ideology that is either based on functionalism, liberalism, or communism, or this and this and that. You can't want to play with land in that fashion. Let me make an example. At a municipal level, and we have had this debate before, there was a comrade from the ANC was saying that all land at a local level must be transferred to municipalities. Then we said, but the problem is that you are saying that statement because you think that you will always be in office as ANC. But what if you are defeated? A government that is right-wing then come into office and it has got all land at its disposal. Aren't you trapping us into something that we don't know? So it is better to put the land in the safe hands, because it is not in the hands of traditional leaders. It is in the institution of traditional leadership, which is the organ of people's power. That's the difference. Don't define traditional leadership according to European prescripts. Traditional leaders are servants of the people, and when they have custodianship of land, they are holding it on behalf of the people, and it is not them who decide what happens to the pieces of land. It is the community, and the traditional leader simply rubber stamps what the community says.
His Royal Highness.
You want me to conclude, Mama? Okay. Okay, let me then conclude by saying that what is the way forward? I've made 2 points of restoration custodianship. The third one is that the institutions of state that were sitting here, whether they will do that in their capacity as the authority of the state or as activists who are in the legal work that they do, we want a process of the rewriting of laws as they talk to the administration, ownership, and everything that is related to land. Let's look at alternatives that are embedded on customary laws, on African laws. In that way, we will be starting a new journey of even writing the envisaged constitution that will decolonize our society. The process of writing that constitution must start. You don't need to wait for politicians to do that. By virtue of the powers vested in us as traditional leadership, we are giving you an order to start doing that work from now going forward. Thank you very much.
Thank you. His Highness, Dr. Zola Mkipa. The new democracy has benefited those that were historically disadvantaged, and has continued to marginalize those that had always been disadvantaged. This new structure gives land to the people who shouldn't have had it in the first place. So thank you. Thank you. I would now like to call upon Zamar Ungwambeki, who is the provisional manager of the Gauteng. Over to you. Oh yeah. Yeah.
I'll hear with the alarm. I'm not
sure how to take it down
It's on. Oh.
for us, yeah, short ones. Thank you so much. Thank you. Good morning, everyone. Good morning, commissioners. Good morning to everyone who is in the room. I've been asked to give a short presentation this morning, and it will be very, very short. It will be less than the 15 minutes, because the perspective that was given under this panel is on the issue of, to some aspect, traditional leadership, its interaction with Section 25. Now, whenever we, and the Native Land Act as well, whenever we discuss the issue of Section 25, the amendments, the issues of land and traditional leadership, there's always a contestation in how will this land be finally distributed, should we get it. And as we discuss these issues today, important as they are about the day when we finally get the land, one of the issues that came out in the keynote address yesterday was the issue of beneficiaries. Who will this land go to and how? And it's not to say that we should not be discussing when we get the land. That's a very important question, is when and how will we get the land? But an issue whenever we speak of traditional leadership within this particular context is what will happen when we get it? And that is the topic that I will be discussing today. Professor Hall argues that the legacies of the Native Land Act, this apartheid era disposition through the implementation of the Native Land Act, are rural poverty and inequality, the displaced legacy of urban poverty and inequality, a social and spiritual legacy of division, alienation, and invisibility, a political and legal legacy of dualistic governance. And this is something that, even as we sit today, reflecting on what is going on in the inner city of Johannesburg with the fire going on, is something that we really need to reflect on, about the issue of land within the urban and within the rural context. However, as we move on, we must ask ourselves, whose land is it anyway? And whose land is it going to be? As we reflect on this topic, we must ask ourselves whether the laws adequately reflect on what is currently going on in society. The laws that we are fighting for, the laws that have been fought for. We talk about different cases, La Mosa, and the different cases that have been brought before the different courts. And one of the reasons that some of these key judgments and these key pieces of legislation have been struck off or kicked off by the courts is that, to some aspect, they're not reflective of the society that we are in now on this day. And one of the key points that we must ask ourselves is that as society evolves, as women are placed in the positions that they are placed, as we have declining rates of marriage, as we have an increase in people living in the same households, not moving out, are the laws that we are fighting for reflective of the society where we are living? We make an example in terms of the work that we do as a commission, where we have so many people who come to us saying that I can't move out of my family home. Therefore, and because of certain laws and policies that are in place, we find that most of the people who are saying this are women with children, right? You're staying at home, you've had your children, your brother has inherited the home, you stay in the family home. Are the laws that we are fighting for going to push and encourage that woman that we're talking about has land in her own right? Right? Second point, the largest group of recipients of social grants are women. They receive the grants on behalf of the children, right? The stats are showing that people are not getting married. We're living alone as women. We have our children. We live alone. God knows where the other guys are. But
But the question is that if we're seeing that women are the largest recipients of social grants, meaning that they're receiving these grants on behalf of their children, how do we tie this statistic to the issue of land? And the normal conclusion would be that 1 woman, 1 hectare. One of the policies that sought to be mainstreamed around 2015, I think it was brought by the Commission for Gender Equality, is a potential solution. And that's not in to contest customary law or how laws that exist, whether it be formal laws, Clara, traditional customary laws, how they can be implemented. But what we are saying is, even in the evolution of customary law, even in the evolution of how we understand communal laws and communal land, are the policies that we are putting in place reflective of what is going on? Somebody yesterday asked the question of, do people really want to live in the rural areas that we are fighting for? We don't know. Do we have the stats? I don't know. When we are fighting for farming land, somebody also asked this, will people become these farmers that we want? We don't know, and that's not what I'm asking. What I'm putting before is that real life statistics that show that where women are placed, they have a great need for land. And that is something that we must not forget in our work. The Constitutional Court, in the Lamosa case, received submissions from the rural women's movement. And the rural women's movement in its submission said, we were not consulted. And this key piece of legislation, His Royal Highness also made mention of it, this key piece of legislation would have been law, but it was not reflective of the society that it sought to be implemented in, because the woman said, in terms of the percentage of the council that is going to be placed, it's not reflective of our society where we are. Now, whether that translates to a 50-50 representation, that's a secondary issue. But laws must reflect the lived reality. Somebody had a question about lived reality. But we can't hide away from where women are positioned. We can't hide away that we've had child-headed households. We can't hide away that the structures that we had previously of, a mom, dad, and then the children, and then the land being passed on through that might not make sense going into the future because of how we are currently living. Now, Clara, there's been different cases that have been mentioned, and everything in between, whether we're talking about the traditional Khoisan Act and every key piece of legislation, has the potential to change the lives of women where they are. It has that key position, and that can exist without challenging customary law and its application. Because customary law, in its sense, has evolved and continues to evolve. Laws applicable now are not necessarily the laws applicable 100 years ago. And in trying to hold on to custom, it does not necessarily mean that we need to perpetuate inequality or perpetuate beliefs that are not reflective of what we have in a country that we are currently living in. And let me just stop there.
Thank you.
I think I get an extra 2 minutes. One of the key things that we see that has evolved in terms of the studies relating to custom is the issues of who makes a decision in a household. And decision making must be reflective of what is going on in the household. So decision makers, in whether we're talking about the family home, those are where the studies need to be done. And if our idea of when we're trying to conduct these studies of who decision makers are, we're using tools that reflect that decision makers would be the head is a male, the mother is the next person. Nakona, in that instance, the mother, because she's female, would not be considered. But what we are seeing now is that we've got female-headed households, we've got child-headed households. And whatever we are doing in terms of determining these laws and in terms of procuring the studies that determine these laws, let's reflect on what is actually going in. And one of those reflections, I think that's what the point I was making on, was that the Constitutional Court said that these key pieces of legislation are far removed from what is actually going on. In my conclusion, the Reconstruction and Development Policy, which was the RDP policy as it was put in place, said that one of its beneficiaries and the key beneficiaries would be women, youth, and those who are living in poverty. And if we were to take that as the foundation on which we develop our laws, and even in our thinking and construction of whether we should be amending Section 25 or not, we should be asking, once we do, is it going to aid these beneficiaries in its construction? Thank you very much.
Thank you, Ms. Mbeki. Thanks for your presentation, which sheds a light on who should be beneficiaries when we get the land. Thank you for shining a light on the needs for our laws to reflect the society we live in today. Before going ahead, I would like to welcome the Deputy Minister to the session. Thank you for joining us. I'd now like to ask Professor Ntama to give us her presentation.
Program Director, Commissioner, and our Deputy Minister from my home province. Allow me to extend the greetings and great appreciation for this invite to share some thoughts on the topic. And also allow me allow me, when I extend the greetings and say the protocol is observed. Colleagues, as the topic of my subject appears on the screen, is entitled The Natives on Transforming a Communal Land Administration in South Africa's New Dispensation. That topic is informed by the purpose of this conference that benchmarks the road traveled since 1913 on how we as the country have fared, particularly with the role of the institution of traditional leadership, on what approach, to what extent is their involvement in ensuring compliance with the prescripts of Section 25(7) of the Constitution. And that purpose is informed by the history of this country, because when the Native Act was adopted, it was classified as a fulfillment of the native question. I view, this is my thought, I view the fulfillment of the native question at the time as a foul naming and classification of the identity of the black citizens of this country. I view that classification as a stigmatization of the role to be played by the institution of traditional leadership in post-apartheid South Africa. Because that naming continues to manifest itself and finding relevance in the constitutional and legal authority that is vested in the institution of traditional leadership. So if we have to view the road to be traveled through the lens of being natives, compromises the dignity and human worth of the general citizenry of this country. I do acknowledge the complexities around the administration of communal land, particularly with these competing responsibilities between the institution and the local sphere of governance. I do acknowledge those complexities. But my argument is the question on the extent to which to balance the role to be played by the institution versus, sorry, I'm taking too much. That was the layout. I got carried out. I'm looking on the extent to which the institution of traditional leadership vis-a-vis the local sphere of governance on how they should craft the way in which they should administer communal land. And in that process, what is the effect of customary law principles on an understanding of the role of the institution on contemporary practices on communal land administration? So, as I address the question of natives being in the forefront in transforming communal land administration, 1994, 1996, it was a universal victory, if I put it that way, for the recognition of the human worth of a person. And that victory endorsed the legitimacy of the status of each of the legal systems that are equally applicable in the Republic. It is that victory that addressed that question, the native one, the native question. It is that victory that gave citizens the socio, political, legal, and cultural status which extended those principles of humanity, humanness, collectiveness on the role of the institution, as they had also been doing in the past. That global triumph brought back the institution from legal blankness. Because in the past, the institution did not have this opportunity to develop its practices and principles along the general system of governance in the regulation of communal land. It was that history that viewed the institution as a mere institution that had to be used as a source of conflicts and divisions amongst the general citizenry. Because it was that past that defined the native as any person, male or female, who is a member of an aboriginal race or tribe of Africa, and shall further include any company or other board of persons or corporate or unincorporated. So that definition touched on the core content of the role of the institution and minimized its authority in regulating communal land, because it became a grave foundation for a construction that was racially divided. As I am in this podium today, the 110 years which was minimized in 1991 to 78 years by the abolishing of all racially related laws. But we still find it relevant today to tread on the footprints of 1913 in post-apartheid South Africa. Notwithstanding the purpose of the Abolition Act, which was inclusive in its approach, even though it had not reached its purpose, it set the tone for an inclusive approach that is evident in section 25. Because your subsection 1 prohibits any arbitrary deprivation of property. And that subsection 1 is reinforced by subsections 5, 6, and 7 of the Constitution, of which my focus is on that subsection 7, on developing measures in redressing the impact of 1913. Way back in 1997, the white paper on land reform was adopted. However, as much as the democracy at the time was still in its infancy, it was a failed attempt. Being a failed attempt is evident in Clara. Because Clara was declared invalid in Tongwane by the Constitutional Court. And it is right to mention Clara was not declared invalid because of the merits that are linked to Section 25(7). Clara was declared invalid because of procedural processes as envisaged in Section 76 of the Constitution. So the merits of whether Section 25(7) should be designed or should inform legal measures that will address the history were left untouched by the court. So today, we have not yet developed a law that will regulate the way in which the institution of traditional leadership will exercise its authority. But we are seeing the regulation indirectly through Section 212. Because Section 212 of the Constitution recognizes the role and status of the institution. But that recognition requires the development of legislation. But that legislation is not speaking to the administration of communal land. The Framework Act, followed by the Traditional Leadership and Cohesion Act, they appear to give content to what I'm saying. Because the Framework Act in Section 20, subsection 1, other than the plethora of responsibilities that are attached to the institution, that Section 21B made reference to B on the role to be undertaken to the institution. But it does not expand to what extent, what land. And the Cohesion Act is also silent, other than making a reference to the general relationship between the institution and the local sphere of governance. Thus, in addressing the institution's response to Section 25(7), this is the challenge to all of us. That the institution has to address the question of being natives on this quest in transforming the role in which we should be playing in giving content to Section 25(7). And the institution should take note that it has been thrown out of the window for restorative measures. The South African National Development Plan in 2030, it acknowledges the role of the institution. However, It says the institution is going to cause confusion and distract the state in the fulfillment of its duties. So the institution is seen as a distraction towards the fulfillment of the role in giving content to Section 25(7). Your Section 24 of the Cohesion Act on partnerships and agreements, there is no affirmation on consultations in developing communal land other than the state to get into partnership. But the institution works collaboratively. As I conclude, customary law is not an independent source that is not subject to the influence of the Constitution. But in crafting the new version, what measures should we adopt? Should the modern system of governance strive alone towards the path of errors that, as it was in the past? Should we not develop the rights-oriented approach in fulfilling the provisions of Section 25(7)? Should the country continue to be the source of instability in the rural land administration, causing concerns to South Africans and peoples of the world? These questions are born by the fact that, yes, history should not be forgotten, but the two systems of governance should safeguard the interests of the people of this country in the promotion of Section 25(7) imperatives.
Thank you.
I thank you.
Thank you very much, Professor, for your presentation, which centers on the administration of communal land with the need to provide clarity on the role of traditional leaders and the local government. At this point, I would like to call on the Deputy Minister to come on stage to give us his presentation.
You see, Program Director,
It's coming.
it's unfortunate that I have to speak just after Professor Makanya, whose height is actually exposing my extent of being vertically challenged. Well, Program Director, representatives of their majesties, our kings and queens of our nation, the real custodians of this asset of the nation. And perhaps I need to give this explanation when I say real custodians. I'm saying real custodians precisely because as custodians, they exercise the protective care over this asset which belongs to their nation. to their communities. It does not mean because they are custodians, they are owners of the asset as it would apply in terms of it being Pty Ltd. But the ownership is communally shared. I thought that point becomes very important because it addresses some of the distortions and malice, especially when it projects the institution of traditional leadership as a feudal system. So that we're able to say, in the continent of Africa, I don't believe that we have a feudal system, because when you talk about the feudal system, there are important inherent presuppositions. Part of those who talk to the elements that characterize a feudal system, which at the heart of that would be about ownership of the means of production. And I would argue and say, in the African context, we don't have any single example of a traditional leader who owns land as his, that is, land that belongs to the community as his private property. So, feudal system becomes irrelevant. The system that we have is more communalistic, not feudal. So it's important to have these contextualized and put into proper perspective so that we have a clear understanding. Let me also acknowledge the General Secretary of the Congress of Traditional Leaders of South Africa, Honorable MP, member of the National Council of Provinces, Ugwanini Usbeu, Nobal, academics who are here, members of parliament, commissioners of the South African Human Rights Commission, members of the Chapter 9 institutions. I see the chairperson of the commission with the longest name, senior government officials, ladies and gentlemen. I hope I've covered everybody. As I was greeting my kings, by extension, I was extending my greetings to all Royal Highnesses, my traditional leaders here. It is my singular honor and privilege to be invited to this gathering where South Africans once again converge as free citizens to take stock of the milestones covered over the 29 years of freedom and democracy. I'm indeed humbled and honored to be part of this conference where we are discussing issues of utmost importance relating to land, which is a very important asset of our communities. To give impetus to this assertion, Frantz Fanon postulates a fundamental posture and aver that, I quote, for the colonized people, the most important essential value, because the most concrete, is first and foremost the land. The land which will bring them bread and above all, dignity. Close quote. So it's important for us to understand that over and above whatever that we have to achieve through the restitution program, at the heart of it was about restoration of human dignity. And for those who continue to believe that despite the colonial and apartheid system, which gave them or arrogated upon them the right to take what did not belong to them, this must talk to their conscience and understand that by that act of dispossessing the indigenous people, they actually denied them the right to their dignity. So the year 2013, in post-apartheid South Africa, that 2023 marks the 110 years since the legislation of the Native Land Act of 1913 was coined. This act is no longer recognized given the egalitarian dispensation effected by the democratic elections in 1994. However, in the light of the reality and persistence of poverty, as well as in view of the burning debates on land, an acquisition into the legacy of the Native Land Act of 1913 in post-apartheid South Africa is fitting. Program Director, the legislation saw thousands of families forcibly removed from their ancestral land by the colonial and apartheid government, which had and still to date negative effect to our people, despite the fact that black people in this country are in the majority. 1913 Land Act is a culmination of what was institutionalized by the 1894 Glen Grey Act, which formed part of the instruments that were used to perpetuate and deepen colonialism, in line with the 1884-85 Berlin Conference between European countries, which included Britain, France, Portugal, Belgium, and so on, Germany, and so on. According to Roger Souther, he captured the conference as, I quote, a colonial intent whose outcome was a doctrine which confirmed that European government would only recognize a claim to any part of Africa by another European power by that effective occupation, close quote. Now you can imagine people in another continent sitting there enjoying whatever that they were enjoying, discussing about how they will balkanize an asset of other people for their own self-aggrandization. And if there's anything that is inhuman, could there be anything beyond that? You come to people, they share with you a sense of humanity. In return, you exercise your insatiable appetite to steal, dispossess them of their land. Over and above that, make them in their own land your subjects of subjugation, your slaves. You make them subhumans. And today, you have the audacity to address international fora and multinational platform and argue that you are the champion of human rights. That is the reality we are living with, which we must confront. The assertion is further corroborated by Piri DeVos when he gives an account of the implications of the Glenn Gray Act of 1894, effectively excluded the vast majority of Africans from Cape Parliament. The Native Land Act was an attempt to ensure that colonial government extends its control to rural communities. Program Director, there's no ambiguity that Chapter 12 of the Constitution recognizes the role of traditional leaders on matters affecting their communities, among which is land. It's a fact that land is an asset under the custodianship of traditional leaders on behalf of their communities. This reminds me of an assertion by Wangari Maathai. She provides what is considered to be the best articulation of the form of ownership of land in its indigenous sense, where she states that, I quote, traditionally, land was owned not by an individual but by the family or the community, close quote. Her assertion is supported by the life president of Contralesa, Nkosi Dilizindaba Olomisa, where he submits that, open quote, communal land is the private property of a given community where individual families are entitled to residential area, arable allotment, as well as communal grazing fields, close quote. In response thus to Section 25 of the Constitution, the democratic government enacted several pieces of legislation to redress inequalities in land ownership for black people and Khoisan communities. As we all know, the land reform architecture of our democratic state is predicated on three pillars, namely redistribution, tenure, and restitution. However, for today's specific content, we are expected to focus on Section 25, subsection 7, which is about restitution. And restitution has a limitation because it sets the cutoff date on the 19th of June 2013. And by all accounts, let's be honest, by 2013, if you go to the Cape, already by 1877-78, that was the last frontier war, which marked the 9th frontier war for 9 wars that were fought over a period of 100 years. So during that period of 100 years, land was dispossessed. You also had other diabolic acts of dispossession from 1880 when the Disarmament Act was introduced, where our people, you go to Amampondo Mise, for instance, King Mhlonhlo is one of the victims whose land and status was taken away by a stroke of a pen, only to be restored about 4 or 5 years ago. Could that be justice? So by 1913, the land had already been taken away. And our people were reduced into the peripheral areas. Rural hinterland. So the reality here is that this is a very important area of our task which remain outstanding. And all of us, all political parties in parliament, must be serious about this. That's why, as the ANC, when we wanted to amend Section 25 of the Constitution, we were conscious of this injustice which was emitted to our people. And to redress that, we had to make sure that we take that path. And we hope that all of us as South Africans, we will rally behind this clarion call to make sure that we restore that which belongs to our people.
Thank you.
Lastly, when it comes to rural communities, Program Director, it's not only about restitution or redistribution. At the heart of it is Section 25, subsection 6, read together with subsection 9, which is about tenure security. That is the elephant in the room. When Clara was invalidated by the Constitutional Court in 2010, you can count, it's 13 years ago. Part of that was technical, as you correctly said, Prof. Because there were two tests, pith and substance, as well as substantial measure. Those tests are very important. I hope there are academics here, and there are students perhaps who want to pursue research. Look into those tests, see how they were applied, the extent to which communities were deprived simply by the exclusive use of one test, which is pith and substance. Which meant that although land is a national competency, Parliament, unfortunately at the time, limited itself to classifying that bill as a Section 75 instead of it being Section 76, because it has a direct bearing on the livelihoods of the communities. Until we address the issue of tenure security, we are still lagging behind in terms of restoring the dignity of our people. Thank you very much.
Thank you. Deputy Minister, thank you for laying on an important context that traditional leaders are custodians and they don't own the communal land. I would like now to open the floor for quick questions as we have exceeded the time for our last engagement. Please, when you ask your question, state your name, your organization, and then you go to state to the question and give the name of the person to whom the question is directed to. Let's see how many hands. 1, 2, 3, 4. 1, 2, 3, 4. Okay, when you ask a question, can you please come to the mic? It's on. It's on.
Thank you very much to the presenters. My name is Nomfundo Ndlogo. I'm the Chief Land Claims Commissioner. My question is directed to both Professor Ntlama and the Honorable Kosipen Ngamashe, Deputy Minister. I listened to the submissions made by Professor Ntlama, and I wanted to find out from her why the focus is on Section 25(7) of the Constitution insofar as it relates to communal land, because Section 25 in total, especially 25(5) and others, talk to what Minister Ngamashe spoke about on the rights, upgrading of tenure rights and administration of land. I'm asking so because even when she makes reference to Clara, she still goes back to Section 25(7) of the Constitution. Why is she not looking at the issues that relate to communal land insofar as it relates to the administration and administration in the context of, for example, Deeds Office, which focuses on urban registration of rights and therefore continues to not focus on the people who are in the rural spaces and their rights. And yesterday, I think we spoke about IPILRA and whether it does secure the rights of individuals who occupy that space. I think the reason I'm asking is because in a way, it goes back to my argument yesterday around the fact that the focus tends to be on restitution, which is legislated to only deal with people who lodge claims and does not deal with the broader issue of land reform. And so by default, we then continue to focus on restitution as the tool to deal with the land question, whereas it should actually be the other way around, where land reform, administration, tenure upgrade, security, both in urban and rural spaces should be the focus. So I want, if both the speakers could assist me, because even the issue of the Framework Act that the speaker spoke about and Section 212 of the Constitution speaks to the aspect of general land reform broadly and not restitution. And my understanding was that the legislation on restitution was to deal with people who lodged, and maybe then the question should be, should we have restitution then as a tool in the context, because it was focused on restorative justice for the specific people who lost a right in that particular space. Thank you.
Thanks. My name is Shirley Mlombo. I am from the South African Human Rights Commission in the Northwest. My questions are addressed to Professor Makanya. In your remarks, you indicated that the institution of traditional leadership is often viewed as a distraction in the land reform process. And of course, that perception is from two angles, from the side of the state, because when we deal with land issues at a local level, the biggest complaint that we always get from municipalities is that they are a distraction, in the sense that they always give out land without proper planning, and that causes a headache for municipalities, because now they have to try and figure out how to get services to communities that were not properly, that were formed without proper planning. and also there is that perception from the communities themselves and human rights activists because of the contribution of some traditional leaders in the displacement of people. In the Northwest, for example, there is this phenomena of traditional leaders just evicting people willy-nilly, especially women, without regard to Section 26(3). People who happen to be the wrong clan, they can just be summarily evicted without regard for Paya, without regard for Esther, just because they're the wrong gender or the wrong clan. So my question to you then is, in view of the complaint that they are viewed as this destruction, what is their contribution to this perception that they are destruction to the land reform process? And are they capable of shaking off that perception? And if so, really, what should they start to do to change that perception and to build confidence that they can be entrusted as, one of the premier or forefront agents in the land reform process in the country? Thank you.
Molweni mphathi hlelo. Igama lami ndingugcina umzi Mahlatshana. I'm from Cooperative Governance and Traditional Affairs in Gauteng, in Joburg. Umbuzo wam ndifuna ukubuza okokubana phaya ku minister deputy minister we Cooperative Governance and Traditional Affairs. Minister, and we know that the governing party some few years back was on its national conference, and the issue of land was discussed, and there's a resolution that says land must be taken without any compensation. I hope I'm not distorting any information regarding that. Now the question will be, kulindwe bani? Because the world, mostly all the continents that were colonized are in a serious bad state based on the fact that the land was taken and still belongs to the oppressors or the former colonizers. Now, apha eMzantsi ke Mhlekazi nilinde bani ngoku, because kuyonakala. You can see even the current situation politically, ayikho normal. You can't have more than 48 political organizations in a small country like this one. Kanizama ukukhawulezisa siyanicela.
Thank you. Sibulise Undabezitha, the Deputy Minister, the panelists here and the chair of the panel, all colleagues present. My name is Taylor Pochali, standing in for the District Mayor of Nkangala District Municipality. Let me start with a disclaimer first. My understanding of coming to this commission in its nature, or in its symbol definition, a commission is an engagement where we have to share the thought. Thoughts might not be diplomatic or technical, but in their nature, they assess the understanding and the belief of society, so that as government, as institution, we don't leave the broader society behind when we transform society or government for the best. But I think we lacked that leg in this commission, where we were, I don't know whether it was because of time factor or other things, but in future, as we arrange future ones, we should allow engagement. so that we engage further. And the lesser attendance today, in my interpretation, might be as a result of that comparatively to yesterday. But let me start by raising two few factors that we should consider. We have a notion of colonialism of a special type in South Africa. What we have found ourselves from 1910 as government start in this country towards 1948 and up to 1994. Now, that colonialism of a special type had its own ingredient that makes the transformation of land not to be an easy process. And we should not overlook that. Because if we don't engage deeply into that the definition of colonialism of a special type means that those who colonized us stayed in the country with the understanding that the country belongs to them and developed it to their benefit to the latter, with the understanding that nobody will ever own the country. And therefore, to unchange that, it cannot be a simple process. It cannot be done on a silver platter. There should be some revolutionary issues that has to take place in the country in order to change those patterns. I want to challenge Section 25, 1, 2, and 3. Those are impetus that makes us not to move forward, even if you want to interpret anything. But more importantly, I want to challenge also the standing of judiciary in South Africa. And I want to give an example about a matter that might not necessarily involve land per se. The 2021 election versus the coronavirus. Now, quite a significant number of political parties and society at large agreed that the environment was not conducive to gather in numbers. People were dying. Judiciary ruled over that. And that is what judiciary in this country. And you don't understand what informed judiciary. Is it some colonial laws or environmental condition that exist within our society? We can debate here, but 2 judges or 9 of them are going to overrule the whole country. Now, what informs that? And that is where we need to start to say, what is it that we should do so that our judiciary should move or adhere to material conditions that exist in our country? The only impetus in this case, it will be the judiciary. We can agree, all of us. We're going to lose these cases in court. And in whose interest? That is a fundamental question that we should address and get it clear. But lastly, I adhere to what Ondabezitha are saying, but I still believe that land should belong to government, a legitimate government that is elected by the people, especially in areas where Ondabezitha are not in the upper hand of controlling society. We should look at that because there are areas where it will be a very serious struggle. To go and explain it to Mapetla Gore, Komapetla Rnale Khoshi or Komletsane and so on and so on. And that must take charge of the land. I think that is my understanding. But in rural areas, I adhere with them 100%. Land has never been a problem in what we call, we don't even have informal settlement. We don't have anything that has a problem in that in relation to land. But however, we need to categorize land into 2 functions, lands for residential and land for economic. And the economic one should belong to the state for the betterment of making sure that the economy thrives in our country. Thank you very much.
Thank you very much, Program Director. My name is Sipho Stephans. I'm also coming from Kokcha. I'm a community development worker. I just want to ask from Umhlekazi Laphana Ondabezitha. You spoke about this strategic plan that we did in 1996 when adopting the constitution of the country, as opposed to, in fact, we repealed all the apartheid laws. So my point is, I think it's yesterday a mention was made of the negotiated settlement that we reached as a country during the negotiations. So in that negotiated settlement, there would have been clause that were binding as to how we were supposed to proceed going forward. So then now, if we talk of us supposed to having done away with all the laws that were suppressing the people, what about then the conditions of those negotiated settlements? Thank you very much.
Thank you very much, colleagues.
Yeah, we don't have enough time to answer the questions.
Thank you very much, colleagues. And I greatly appreciate the thought-provoking questions that are giving substance to our presentation. The question is, why focus on Section 25(7)? I might be biased because of my rural background. I'm from Ciskei, where I had an experience of living in the village. And even today, I'm still commuting 74 kilometers to work and go back home. I'm staying in that village, so I know the experience of living in the village and also the relationship between the residents plus their leaders. The focus of my presentation on Section 25(7) was to dispel the myth of rural people being natives in this quest of developing or of making contribution towards the measures that will address the historic prejudices in respect of the way in which the institution has to administer the land in which we live. We were displaced and the monies were paid because people were moved from that other area to that other area. So to what extent does or do the institutions of traditional leadership was involved in restoring people to the position they could have been if it was not for the history? So my emphasis was on the extent of the involvement, on crafting that particular legislation, and also how would it benefit the people living in rural areas. My colleague made mention of that. But who are these beneficiaries? The other question from Northwest.
Professor, we don't have enough time. Just round it up.
Okay. The perceptions from Northwest. These perceptions, they are worrying because some of them are officialized. If the plan to craft the future that we have to make it work in South Africa says this institution is a distraction, to what extent would that officialized perception transmit to the people that are led by traditional leaders? Let me leave the ones for the minister, but let me also share this. In my other cap, I am a judge, Mr. Taylor. So judges speak only in court and only in court. They can't defend themselves in public. Thank you.
No, thank you very much. In the interest of time, let me just zoom into the question about the strategic plan. What I said was that when we were in the struggle, we said when we defeat the apartheid state, we will repeal all the apartheid laws which were racist and which were subjugating us. And we never had a view that we will even inherit any piece of legislation which was part of the apartheid instrument. Now, the negotiated settlement produced an interim constitution which gave effect to the government of national unity. Between 1994 and 1996, we should have done everything in that period of 2 years to produce a document that would have cleansed, because the intention of a negotiated settlement was to neutralize the enemy. Now we were already in office. We had 2 years of preparation towards 8th of May 1996 for the adoption of the final constitution. Be that as it may, colleagues, a constitution is a living document. The sovereignty of the people is above the constitution. Put it differently, people do not exist for the constitution. The constitution exists for the people. If a constitution suffocates us and is not doing what we expect it to do, let's just change it and implement the things that we want to have on it. Thank you very much.
Well, you know, this thing of, let me just handle it. Well, thanks very much, Program Director. I'll probably take just a minute or two. Maybe the first thing is to say, Commissioner Kobodo, you are right. We need to look at the other pillars of the land reform, namely redistribution and tenure. Because that's where the bulk of the work resides. Even if you are to look at the judgment by Judge Mahlala in 2014, to the extent that it dealt with procedural matters, but the issues that were canvassed in terms of addressing the historical injustices, quite specifically to cover the Khoi and San communities who were at the cold face of the brutality of colonialists. I don't think a sound-minded citizen of South Africa can contest that fact. So on merits, it's not an issue. It was only a matter of clutching on straws by those who could see the heat coming, galloping, because the issue is about those fundamental reforms which we must address, and we have to. We can't negotiate about them. This country, when it was taken away, it was through the barrel of a gun. There was no negotiation. So all it says is that that's the revolutionary part which we must incorporate. And even our colleagues, our own people who sympathize with whatever. But on this one, let us be one, because it addresses the plight of the poorest of the poor. I think the other issues, Chair, as they would relate to expropriation without compensation, those, when we have time, perhaps the methodological approach, we just have to address it so that we can improve on how we deal with these issues. Because it's a very important Chapter 9 institution, because it deals with the fundamental human rights of our people as enshrined in Chapter 2, and any other rights for that matter. So it's critical that we give this time and make sure the full participation of the citizenry and whatever we come up with as a recommendation is informed by that maximum participation of our people, because it is part of the character of our democracy. We are first participatory before we become representative. So our representative aspect must always take precedence. And I think all these judgments, whether you look at Tongwana, you look at Madlala, they all put emphasis on Section 59(1)(a), Section 72(1)(a), Section 118(1)(a), which is about public involvement in the process of lawmaking. And lastly, the Constitution. Judges, I don't want us to go here with a wrong impression to say judges or question the credibility of judges. Judges interpret the law. So as parliamentarians, we must make the law that makes it easy for the judges to interpret the law in the interest of our people. Let's go and amend Section 25 in the interest of our people. Thank you very much.
Thank you. Thank you to all my panelists. I would like to hand over the platform to the program director. Thank you.
Ladies and gentlemen, we have to agree that that was quite an interesting session. I felt like we were sitting in an roundtable discussion at some university, debating the issues around the Native Land Act of 1913. But I was quite taken aback, you know, when the deputy minister actually talked about the Glenn Gray Act and how Cecil John Rhodes actually played a very important role in developing that act, which laid the foundation of the segregation that we find ourselves in today when we are trying to dismantle that segregation. And under the land issue, it's a very foundational issue. So on that note, I would also like to say that, Gosi, you brought up a very important matter about the rupturing of the colonial state and how we have really inherited some of the legislation because we have not fully ruptured that colonial and apartheid state. And most probably, the land issue is one of those examples where we can actually even say that the negotiated process into a post-apartheid state laid those foundations of saying that, are we a ruptured state in South Africa? I think that's a big question, and that's why I'm saying that this panel really raises a lot of intellectually provoking thoughts about South Africa, and the land question becomes a thorny issue because of those fundamentals. But then in our next session, we have civil society organizations who are also going to take us through their thoughts about Section 25 based on the experiences that they've had in dealing with this issue. They've been working quite closely with communities. They also work very closely with academic institutions, and maybe their contributions might also help us to understand what kind of state do we want to see coming out of either expropriation with without compensation or expropriation with compensation. So let me invite the next panel members who are going to come on stage and take us through their thoughts. And these panel members are Siyabonga Mahlangu, Dr. Gaino Paraza, and Ms. Tsepo Fokane. Now, Mr. Siyabonga Mahlangu is from the Inner City Federation. Dr. Gaino Paraza is from the Public Affairs Research Institute. And Tebogo Fokane is from the Land Access Movement of South Africa. This session will be moderated by our Commissioner, Chris Neeson. If you guys can come up on stage and really give us your thoughts. Thank you very much. Yes, so you have a question? Go. Yes.
But there's one item I want to clarify on, which was said by the Honorable Prince in his last comment. I'm saying, sorry, Doc, I don't want to withdraw the conference back, but there's one important issue which was raised by the Prince, I think on his capacity as a parliamentarian and as deputy minister, to the effect that, you see, and then, Section 25 has to still be amended, which there's no problem about that. We all agree with that. But also, there are other permutations around Section 21, which came up quite strong than yesterday, which we also agreed with. But I want to ask this question. Now that it has been quite very, very challenging to actually amend, because there was an attempt, a very bold attempt, but it was not successful. Now that the ruling party is more fragmented, and the reactionary forces are taking center stage in parliament, and in the next coming, in the 7th administration, we're not sure as to what is actually going to happen, but what is getting clearer and clearer by day by day, is going to be difficult to get 67%. What are then the modalities? What modalities now do you think are going to actually work in terms of amending Section 25? You can always answer that later on.
I was about to say that most probably what can be done is that after this session, as more questions come through, we can also try to address some of those unanswered questions, but we also would like to give this panel an opportunity to present. So, Commissioner, please take over. Thank you very much.
Good morning, colleagues, and good morning to the Minister, and morning to all these excellencies and from royal houses and colleagues from government departments, and particularly now our three panelists. And welcome here this morning. And we are running a bit behind time, and I would like to acknowledge the Chapter 9 institutions, and as the Minister said, particularly the chairperson of that commission with the long name. Prof. Thanks, Doctor. We are running behind time, so I'd like us to stick to the timeless. But I just want to say one thing in terms of the Native Act, in which we're now commemorating 110 years. The one of the things that I think we should be, not for today, but going forward, is to look at the impact of the other acts that followed out of that. If you look at the 1963 Native Territorial Act, if you look at the Apartheid Acts that came in, the Group Areas Act, the Vagrancy Act, and all of those that were accompanied, and of course the Bantu Urban Areas Act, that effectively kept people out of the cities and the townships and so on. But that's perhaps for another day. So it's my pleasure then to call upon our first speaker, Mr. Siyabonga Mahlangu.
Hi everyone. I'm not sure if it's good day or it's morning. I'm Siyabonga Mahlangu from Inner City Federation. Since I've got in the room, but even though I got in the room later because of some circumstances that are happening in the town, I'm sure some people there, they see what is happening in the CBD of Johannesburg in their social medias. So we were there to try to rectify that. I had so many interesting discussions since I joined, but there's some things that we think they were left behind in all laws that they were being mentioned, even the case laws that are being mentioned. As the person that is working directly with the communities, I don't think they do benefit the communities. As we speak now, we are waiting for the parliament to rule over some submissions that are being made by some organizations in terms of a PI Act, where they are saying now a person occupy land without the owner's consent, that person must be criminalized. So we are still dealing with such problem, but we are talking about land for people, of which it will take us some time to access that land. But what comes to my mind are a few questions that we should look whether what causes the problem of not people accessing the land. We can look at it in so many ways, but for me, I'm glad that some commissioners are within the room saying that the law itself, it's a problem for us to access the land. The deputy minister says that the land was taken by the force, by the gun, but when we are trying to do so, we are criminalized, we are being arrested. So for me, I think the whole Section 25, it's insufficient. The way I see things happening and on the ground, not on the book. I think the people who can rectify and make an adorable act of Section 25 are people who are directly affected, of which I think if they are being consulted, that they can assist to rectify what's happening here. Because so many things that are happening in this, I can see that we can ask ourselves so many questions whether or not Section 25 serves an obstacles, but rather ask ourselves that our policies have lived up on the constitution of clarions for a call of land redistribution, of which it's not happening in this time. So I think in so many ways we can try to interpret this section. Each and every person, he or she will have its own interpretation. As its judges, they have their own interpretation when it comes to this. I remember even the Constitutional Court said that the owner's right can be suspended in terms of access to property in some eviction cases. So I think in this room we all have the task. We can do that today, but I don't think it will help until we've given the chance to rectify this in a way that each and every person that is directly affected being given a chance to comment or give some submission on that. Because at the end of the day, the people who are taking decision are people who are not directly affected. I'm talking that based on the experience. I'm not going to relate this to any law because I'm not living a law. I'm living in a space of reality. So for me, I'm sorry to say this, Section 25 doesn't exist at all for pro-poor people. Maybe for rich people it does exist, of which I'm not sure because I'm not in that class. I'm only living with pro-poor people. Of what I'm sure of, it doesn't exist at all. Instead, it's keep on creating more problems for them in a way that it leads to them losing their homes, losing their lives, trying to fight for access to land. We've been trying to communicate with the Parliament, President, Deputy President, Ministers. We also, this month on 23rd, we did some submission where we're saying President and the Minister, they should donate land to people using some acts that are put in place for the President and Minister to do so, of which we are not sure if they will respond or not, the way that we see things, but we have that hope that they will do the right things in terms of the laws that were put in place, like Land Disposal Act that says they should donate to the poor people the land that they have so that they can have access to their homes. So that's why I'm saying on my side, I can't relate to any act because I didn't see those acts assisting the poor people. But it will be my request that if there's something that to be done in terms of Section 25, 1, 2, 3, 4, 5, 6, 7, 8, the directly affected people, they should be contacted. They should make some submission on their own, not being assisted by some academics or lawyers or NGOs, because they will put it in a nice way that the Parliament won't see the need of rectifying that Section 25. That's my submission for today.
Thank you so much. We always need those kind of voices, because without those voices, out the conscience of those who make decisions will not listen. So you're the conscience of those that makes decisions. Thank you so much. Colleagues, perhaps I wanted to say before we started, perhaps this conference, this land conference should also note that currently the death toll is standing at 73. And so perhaps we should extend our condolences to those who have been affected, and they're still looking for more bodies. So perhaps we should just make a note that we extend our condolences to those family members who have members that perished in that fire. It's my pleasure to call upon Dr. Gaino Parazza. Welcome him.
Thank you. Good afternoon. Sorry. My name is Gaino Parazza, and I'm with Public Affairs Research Institute, and we are affiliated to both the University of Witwatersrand and the University of Johannesburg. So I'm standing here kind of wearing academic, CSO, practitioner hat. And I want to make some contribution regarding the most important topic that we're here to discuss about how do we gain traction or pick up momentum in terms of the Native Land Act that was passed. So I think I'll start by telling kind of three case studies. One of them is there's a colleague at the University of Witwatersrand. Some of you know her. She's called Dr. Dineo Sikosana. She works mostly on issues of compensation when large corporates want to take over land or to build a mall and communities have to be evicted. Mostly she focuses on graves, the relocation of graves. And every single time there's a frustration and or she gets a frantic call from a community and they sit there and they try and negotiate, beg the commercial farmer or the entity that is holding the mining rights to see if a family can be allowed to bury their loved one, can be allowed to go and pay respects, the issue of dignity. Every single time she's doing this. And yet this is a right that is enshrined in the Constitution. People have a right to benefit from the land in terms of dignity, in terms of observing their cultural and spiritual rights. And this is a tragedy that we live with every day. The second case, I would like to make a reference to some work that was done by colleagues at an institution called Association for Advanced Rural Studies. It's AFRA, based in Pietermaritzburg. They did some work in 2018 where they went on farms and they mapped 850 people who were living on commercial farms in terms of the location, the number of households who stay there, the GPS location, the services that those people have. So in effect, they gave those people an address. And I'm giving this two examples to highlight some of the lacks that we live with in terms of the constitutional provisions versus what we see when we have to implement the work on the ground on a day-to-day. And in terms of the work that we do ourselves as PARI, we are also involved in some work towards what we're calling achieving a coherent conversation around land administration in the country. And if you listen to the submissions we've had the last 2 days, where traditional authority, respective commissioner, minister, CSOs, people from the South African Human Rights Commission are speaking past each other. Just even on a simple issue of who do the traditional authorities answer to in terms of land, which is the department that is in charge of the land. And we had earlier this morning the Commissioner for Land Claims seeking clarification. And that is the kind of work that we're trying to do at PARI to say, how do we have a coherent conversation around land administration in the country so that when we speak and we use these terms, we are talking about the same thing, because we don't seem to be doing that at all. And if we're not agreed on terminology and frameworks, how do we measure the progress that is happening? So in terms of land administration, we're talking about the land-related institutions, the policies, the laws, the strategies, the plans, and the institutional arrangements in place. How do we make the goals? How do we make sure that we are proceeding? How do we measure success? How do we measure failure? How do we reconcile competing claims? So in terms of conclusion, I had kind of five recommendations to make. One of them is about us as non-governmental actors, as CSOs, as scientists in academia, maybe as private sector. This work is for everybody, not just for government. But for example, specifically for the CSO, we only meet government in court or on the road protesting. There doesn't seem to be any other space for us to bring in what we have to inform policy making. I think the space of interrogating Section 25 and making it workable needs to be broadened and more inclusive. Government needs to begin to think about developing a platform where we can engage with other actors on terms of trust and moving forward. And that is why I gave you those two examples I started with, for the work with AFRA and the work that people at the SWAP are doing. Because if you speak to a government official, you know, we talk about, as a government official, we talk about, we don't know how many people are seeking restitution, how many households are there. You know, we talk about them as a mass of people. But I was giving you examples of the work that is going on to make those tangible, measurable. But the work is, the call is for government to accept and begin to work with some of those institutions. So we also need to look at CSOs, because they are the places where innovations are made. That's why I gave you the examples. They can record the so-called unrecordable land information systems. They can identify the number of people who live in a building using their own measures, which extend beyond government. And also they have capacity to learn from people who are living with experience. And then the other thing I wanted to kind of make a recommendation on the Section 25.7 is, it has been coming through the room the whole 2 days, is about the legal-centric. The way that lawyers, judges, I'm not personalizing, are kind of privileged when it comes to making land laws and working with the land. And there's a way that law works that makes it expensive, exclusive. It even fosters inequality, and it reduces things that can be explained in other ways that are not necessarily the law. And there's a need for us to broaden the way we think and talk about land rights. For example, norms, standards, guidelines, values. I mean, it's encouraging to note that the special master who's dealing with the land claims with the labor tenants is now have been allowed to record people's stories and experiences as evidence that can be permitted in court as their land claims. That is an example of one of the ways in which I'm highlighting the limits of this focus on the law. Somebody was talking about stories yesterday, memories, dancing, those kind of things. So that is the call that I'm making, that we need to broaden. But this kind of other ways of producing evidence and administering land need to be institutionalized and recognized, not as an exception, not as some hobby, but as real knowledge. And then lastly, I would just make a conclusion in terms of what do we need to do to make the land administration work. We need to integrate South Africa's highly fragmented and dualistic land administration systems so that all land rights have the same value at law, not have one being inferior to another. Like the popular duality, people talk about informal, formal, customary, private. We need to find ways of reconciling this. There's a need to work on the state capacity in terms of making land administration accessible. There's a need to adjudicate land rights through administrative means. This will reduce the bottlenecks that I've highlighted, as well as deal with the other ways in which using the laws and the judges and the lawyers limits the work that can be done, and in terms of the progress that we can make. And then we also need to broaden the way in which land rights are recorded. I'm not going to labor the point I heard yesterday, and this morning somebody gave us an example of how it is not an exception when women are seen as head of household. It is now a norm. And we need that to be recognized in the way land rights are recorded and presented. And the way in which land information is recorded, it needs to go beyond, the things that can be recorded in town, to incorporate other ways in which people make claims on the land. And the rights that are not currently surveyed need to be recorded and represented on the maps so that this can be represented and presented as tangible evidence for purposes of compensation and argument in court. I'll stop here. Thank you.
Thank you, Doctor. I think your request for space, and I thought that this conference was given a platform for that space for the different stakeholders from public, government, academia, etc. And Commissioner Sibanyone, who runs this portfolio, probably will take care of that, but we also have our Chief Operating Officer here who will take note of it in terms of part of the outcomes of the conference is to create that space. Thank you so much, Doctor. I now call upon Ms. Tsepo Fokane. Welcome, ma'am.
Dumelang bagolo. My name is Tsepo Nini Fokane. Yes, I am a member ya La Mosa because I come from a land claimant community, but today I'm actually speaking for the Alliance for Rural Democracy. So it's been such an engaging and enthralling 2 days, and our proposals really are quite easy because we've already heard so many in the room. What I'd probably start off with is that restitution is probably overburdened, primarily because we're thinking of restorative land justice in one way only. The fact remains, when we saw the maps, we got a visualization, but people didn't only lose land. When you were moved off or the farmer changed his mind based on the laws available, you had to reduce your livestock, you had to probably reduce your plowing fields. You, in addition, if you had to leave the farm, had to relocate immediately. People who drove their cattle to the next settlement will tell you, you can never be restituted for the loss of livestock. The commission officials will tell you that we don't have a budget for. So what actually are we compensating people for, right? More than that, I'm thinking of other communities that I really exemplify why restitution has to do more than what we have actually burdened it to do. I'm going to refer now to the Minga community. Bako Limpopo, there are people who were relocated for the purpose of making Kruger National Park. It's wonderful, they got their restitution claim. That's not all they lost. They were then forced to lose their identity and fall under, it's the Maguleke people who were forced to fall under the Minga. So what did they do? They lodged a dispute with that commission, you know, whether it's Yonhlapo and Mini. The province ya Limpopo, the Provincial House of Traditional Leaders, didn't make any findings or objections to saying that, no, in truth, the Maguleke CPA, the Maguleke people are independent. So they go to court. We are overburdened with court because what more can we do? When restitution claims are being adjudicated, let's consider what people lost. Let's think beyond the farms, the loss of livelihood. Let's really understand there's been these distortions of identity. I have the privilege of following the last panel wherein we heard how important traditional leadership would be in terms of communal land and, tenure reforms. My point of departure would be for the Deputy Minister. Let us please see regulations gazetted on traditional council elections. If not, then the same institution, the Traditional Council, is signing deals that could benefit the community. Let's make it the ideal world. Appealra is permanent. We have regulations of Appealra. Everything is in force. But what happens? Those individuals, if we don't have the 40% elected through our elections process, then in fact, it's not actually constituted correctly. The same traditional council should have 30% women. When this morning, Mambeki was talking about, one woman, 1 hectare, that is a clarion call we have to stand behind because we already know for redistribution, women are only accessing land when they are in a group, a co-op. You can hardly tell us what did I, as an individual woman, receive from the state? How many hectares are in my name, right? Because for as long as you lump us that way, that means we have to access our land rights with our husbands, with our children, with our neighbors. But what we want to see is land in women's hands. We want to tackle food insecurity. We want to tackle all of the other challenges that women are facing in rural and urban areas. If I just look at proposals, it's really interesting because Dr. Gaynor also mentioned, you know, the work being done around incremental upgrading on the farms. Putting basic services on private-owned land is another way to secure tenure for the people living there. So that already is happening. The municipalities are capable for your backyard dwellers, shack dwellers. We've seen this happen. So we learn lessons in the rural work we do to say, these are other ways that we can protect people. More than that, I think we can also learn the very valuable lessons around recognizing off-register rights. 60% of the population does not have registered rights. That's all of us. I'm saying all of us, that's the bulk of the population, right? So what could we do? We could, yes, you know, use this battering ram, the law, or we could look at what's already happening. How are people actually navigating that? For example, we could do legal and administrative recognition. What does that mean like? What does that look like, you know, when there's an occupied site? It means things like we have a service map, we can have block layout, we can have our own land recordal systems, right? We don't have to necessarily punish ourselves and say, let the Deeds Registry Act be amended. Because when we get there and we say the Deeds Registry will now amend and record our unregistered rights, what right are they recording? In whose name? How does it get transferred? Are we not going to make people overly burdened in another court process each time you want to inherit or something? What would happen practically? So we could use ways that are not compelling us to spend all of our energy in a courtroom. Certainly from us, I'd say, no, we don't have to amend Section 25. What we want to see is the Commission on Restitution finalize old order claims. We are desperate to also see Parliament, MPs, enact legislation on the Restitution of Land Rights Act. Please, without that, all of the hundreds and thousands of claims from 2014 to 2016, how are we going to adjudicate them? We don't actually have something in place. Let's leave the budget and, you know, the human resource. We don't have the law. So even if the commissioner got the billions and billions, right? Tomorrow, we're finished. What are we going to do? What's our plan, more importantly? Because we're realizing from obviously what everybody's saying that we didn't tackle land reform or restitution appropriately. We were a bit quick in some instances, and for other claimants, they only received a piece of paper that said, here's your acknowledgement of your claim, and they're waiting 30 years on. So we can't punish the next new order claimants either, right? And we've got to think differently. There are so many challenges that we know that the Commission on Restitution is facing. We know there's bundled claims. We know that many have been wrongly consolidated. We also know too many claims lodged by traditional leaders were finalized at the expense of individual claims by families, households. How possible is it, right? Because the department has this stance with the Commission that we will deal with these claims, they will deal with those claims. So tenure, we don't entertain as the Commission. Fine. What ends up happening? One farm, I'm going to mention SAHRC, Mpumalanga, they are individual labor tenant claims using the Labor Tenant Act. There are individual restitution claims, but looking at their history, they're labor tenants. Who's the current owner? Manala Mkibe CPA lodged by a traditional leader. So we were quick on some of the claims, super quick. So quick, I don't know what kind of research we could have done for all these properties, be it urban, be it rural. And on others, shockingly slow. When we talk about land reform, I think that restitution is a key, but we also have to think bigger. Let's get some water reforms. What joy is it to inherit a piece of property from government when you don't even have any water rights? Hey? What joy is it when, fine, the mine is operating. You purchase that land or you own it under customary law. All you have is a surface lease agreement signed by traditional leaders, men in a room. We weren't there. When we want to question, we're locked now in legal processes. No, the lease is in force for 90 years, 30 years. Our kids want jobs. We also have dreams for rural land. We have dreams for urban land, right? Unfortunately, what is happening is that we are treating people who have land hunger and land demand, like Sia saying, criminalizing them. There's a reason that people need a place to live. We need to belong. We want one South Africa for all. Thank you.
Thank you so much, Tsepo. You are leaving us with a lot of things to answer. And Commissioner Gobodo is here, and I'm sure she will be looking at some of those things. But I just want to raise two issues, if you don't mind. One of the issues is that, you know, with those who lost land under the Group Areas Act, many went to towns and urban townships, and they opted for financial compensation. And that financial compensation lasted probably just a month or 2 months. And then they still become backyarders and homeless people. So I think that is an issue that we really need to look at and so on. The issue, of course, about the CPAs. And we pick up a lot of problems across the country with regard to CPAs, because CPAs become political block and power. And then in the end, the acceleration of access to restoration or to distribution or whatever, it's taking a long, long time. And so I think we need to look at that as well. But thank you so much. Colleagues, we now open. We've got a few minutes for questions. There was a question raised, which I'll hand over to you. Thanks.
Thanks very much, Facilitator and Commissioner. I think the question that was raised by my colleague on my extreme right is very important. And my answer is simple. I think it is for South Africans to decide. Because as ANC, not only were we failed to pass the constitutional amendment, which we believe that it was at the heart to redress the equitable restoration of equality and human dignity. But what this failure so glaringly exposed was the extent of hypocrisy and what we consider to be treacherous betrayal of our people, especially the dispossessed indigenous communities. So that is why today the parties whose lineage is direct beneficiaries of colonialism and apartheid are so emboldened, even in parliament, to show the majority of this country the worst disdain. Derogatively, I can say, they show our people middle finger. So, again, it's for South Africans to decide. We are going to 2024, they have an opportunity to decide. That's all I can say. And of course, perhaps let me say to Tsepo, IPILRA can never be permanent. IPILRA by its own definition, it's interim protection of Informal Land Rights Act. That act was passed in 1996 with envisaging that the final constitution will give effect to a land reform that will guarantee South Africans security of tenure, which unfortunately in 2010, though Clara was passed in 2004 as a response to that, but then in 2010, by way of the Tongwana judgment, it was invalidated. So it's important to say, as if we can expedite the passing of a legislative instrument that responds to Section 25, subsection 6 and 9, that will then mark the end of existence of IPILRA. IPILRA is relevant to the extent that it has to provide those guarantees as well as ensuring the consent. Because as I said, land is owned by the community. So the consent, it becomes very important, especially if you look at consent in terms of your international instrument like your FPIC, which is very critical. That consent is not just any consent, but it must be informed and it must be free. So those are critical principles which we must actually look at. And there are other instruments, whether you look at the displacement and resettlement models. I think the World Bank has got those various models that could be looked at when you apply and employ restitution theories. I thought that perhaps would come closer to what will be helpful. Thank you very much.
Thank you.
Thank you so much, Program Director, the Honorable Deputy Minister, and our Honorable Queens and Kings. We are dealing with a very important matter whose history has been clearly defined, clearly propounded to us. And I don't think the subject of land is for the first time that we are dealing with today. There has been many colloquia, seminars. The question that remains for this commission and for us is whether we want to continue the trajectory of lamenting on a history we know, or we feel much more assuaged by the pain that is normally visited when we recollect what has happened to our people and to us as a whole. The question was raised yesterday, when do we get our land? And I think that question is very urgent. It doesn't require any pontification. It doesn't require writing of long stories, long papers, research. It's an action-oriented question. First, what are the inhibitors? Because unless we know what are the things that stand on our way, it's very difficult to proceed. What are the inhibitors? Are those inhibitors within our capacity and powers to deal with and solve? If so, by when? Time frame. Second, what are our enablers to achieve the objective we set for ourselves? If we say that the enablers is the Constitution, and many have cited Section 25 as a problematic section, which requires interpretation. If we were to delve on that, how much time would it require to get to an interpretation which would help us to acquire the land, to get the land restored to us? Unless we deal with these agencies, at the end of the day, we'll not be able to prescribe precisely what it is that can be achieved beyond today's what you call conference. We need to be more action-oriented and less historicity. Because history can be told any time. But the agency is how the extent to which you are able to achieve the intended objective. Part of the problem is that we believe too much in talking. We are not system people. Hence, conference after conference. Apartheid people or apartheid government was able to keep us where we were because they created systems. You know, you would not walk at 6 o'clock in the evening on the pavement. Why? Because there was a system accompanied by power, by police, by everybody, and legislation. But if you have power and you don't use it, and you lament over the power that you have, who must be blamed? Indeed. So we should not come here and create a conference of lamenters. No. We are in power and we have the capacity to realize our aspirations. Why don't we do it? We are going to say somebody must do it where? Let's agree. Come up with a very pointed out, well orchestrated strategy and plan and say, this is what we are going to present to government. That's my feeling. I've attended many conferences and I'm tired of repeating the history of this country and its pain. Thank you.
Thank you, Chairperson. Colleagues, the Deputy Minister has to leave now. May we extend our word of thanks to him. And thank you so much for your input. And I'm sure that you've listened what the Chairperson of the CRL said. Thank you so much, Deputy Minister. The second question. Yes. Over here.
Okay. The second question.
Thank you again. I have one point and then a question. The very short point is that it occurs to me that when we're talking about the language that the law uses, colleagues here in the Inner City Federation and others have to admit that they are unlawfully on land in order to get the protection of the law in South Africa. And this, despite the fact that PI does protect many, many people from eviction in the country, I think that it really is something that the government should look into and Parliament should look into changing to get people who are living on land which they feel rightly is stolen from them to have to go to court and say, I am unlawfully here. It's a problem, and it's something which is a legacy of the way that we looked at law before apartheid. But then the question to colleagues in civil society organizations is, you've heard a lot, including from the Deputy Minister, about and others about, you know, changing the Constitution. But if the reality on the ground is that people are not feeling what the laws say and feeling what the Constitution says, does it matter if we change the Constitution at all from your perspective? Does it matter if the laws change? And what is it that from your perspective as civil society organizations should be the priority of government? Should it be trying to change laws and the Constitution, or should it be pursuing the implementation of laws?
Thank you so much. Can I just have an indication of how many people want to ask questions or comments. So you go ahead, ma'am, and then Ms. Koboda after.
Okay, thank you very much, Program Commissioner. So my name is Zukiswa Mkolomba from the Public Service Commission. I'm the Deputy Chairperson of the Public Service Commission. And I wanted to affirm the statements and the input made by the Chairman and Commissioner that it's time for action now and it's time for implementation. And I think one thing that comes out very strongly from this conference is, as a next step, is that the Chapter 9 institutions working together with civil society organizations out of this conference needs to have an action plan for how we will take the issues raised at this conference to government and ensure the implementation of our recommendations. So this is a point that I wanted to stress. Enough talking, it's time for action. Let's come together as Chapter 9 to 10 institutions and put together an action plan that will enforce government to take responsibility for land reform in this country. Thank you very much.
Thank you so much. The commissioners from the chairpersons and from the Chapter 9 commissioners are here. For those others that are here, please take note of that. And I think it will have to be coordinated by the CEO of this Human Rights Commission emanating from this conference. Thank you so much. Please, ma'am, go ahead. And then, yes, sir, acknowledged.
Thank you very much to the presenters. I just wanted to find out, insofar as civil society is concerned, what do they think their role is in assisting communities who have received land, in holding the land, in ensuring that they abide by the governance, and ensuring that the most vulnerable in that community actually gets to benefit from the resources that the state has given to them. Because very often the perception is that it's government that must do something. We've restored the land, we've given it to the communities in the context of how they said they wanted to receive the land. But when the communities, not even communities in instances, sometimes it's families fighting amongst each other. Civil society themselves come to us to say we must sort out that problem. But what is the role of other stakeholders in that context? Thank you.
Thank you, Commissioner. One last one, and can we be brief? Because we are really running out of time.
Oh, hi, sorry. May we please share the 120 seconds?
Yes.
Okay, so mine is a comment and it's going to be very brief. I'm Ngobile Mnisi from the South African Bar Association. It was 1976, right? When our predecessors took action and they showed that it can be done in restoring. We're talking about restitution and restoration. It's all talk. 1976 proved that we are capable of taking back what is ours. I think the sooner we position ourselves and we will be able to have less conferences and be happy people with the land as well. The other issue is in terms of the Criminal Act, those traditional leaders who are dispossessing their own people should be charged criminally, because we are working towards something. We are going 10 steps forward, you are taking us 20 back. It is not going to work. So that CPA needs to work on, and also traditional leaders, how we're going to deal with traditional leaders who have lost the plot. So yes, it's time, moderator, that we take over. If the elders do not do it, very soon the young people are going to do it. They're on the ground. 1976 was done by the youth. We are going to do it, and it's going to be done fast. 2024 elections will arrive at a time where we have taken over, because we are tired of a state that is a sheep leading lions. Thank you.
Thank you so much for the comment. Over to you, sir.
Thank you very much. I'm Mr. J.N. Mukwena from Watts Forum, is Workers, Occupiers, Tenants, Dwellers Forum. We don't want to be part of the lamenters in this conference. We want to be part of the solution, the people who's giving solution. We want to share one of the good things that we are doing. We are getting that land. from those the farmers who are holding the land. Let us tell you, we need to have what to call a team in the department that pursue these people who we are saying there are problems. Some people, they don't need to go to court. You need to go and start to negotiate, and then they are not wasting even 10 minutes. They agree even 5 minutes of the meeting. They agree, and then we find it difficult to agree with other parties that they say there's a resilience of this land. Somewhere there is resilience, but they need a commitment in the department to have a team. Maybe that team, we can work with them. We, as a civil society, we are getting a lot of land. The last land we got now is 80 hectares for 8 households. We called the department. We are working with them. Sometimes we expropriate land from them that they gave it to their friends. So we are not so good friends for them, but we work with them. JP Spanyon will tell you, he's following us. He's a commissioner. He's a lawyer. So we have seen that we are investigators. Good one for that matter. Make no mistake. We can help department. No one is funding us. We are working from our own pockets, and we are doing good. We got a lot of land all over the country. This man is coming from Mpumalanga. He gave us now 50 cases. This one here, we are dealing with them, whereby the CPA are in shambles. CPA, the one who is leading the CPA, maybe he need to be shown the door. He must go, or she must go, because there's no management there. You understand? So the question that we raised, that what is your duty when this CPA under your watch is getting into shambles? You understand? It's deteriorating. We spoke about the beneficiaries process. The public protector was here. She has confirmed that 21 cases whereby the officials have stolen land for themselves is there. So it means that the project managers are they are the enemy to the people. So there's a lot to talk. There's a less time now. We need to talk. We need to talk honestly in front of everybody. Thank you very much.
Thank you so much for the good work that you are doing. I'd like to ask any of the panelists, because mostly were comments, but there were 1 or 2 questions that if anybody wants to briefly respond to it.
I hope you don't mind if we take this sitting. Commissioner Nomfundo, our role already is to democratize and push for rural democracy. So the same principles we want to see in traditional councils, we want them in CPAs and trusts. Our challenge, however, is that we cannot compel them to work together, but we are already doing this mediation. We have taken on this social worker role in a way that we're actually not funded for it, but we are obligated to do it, because if we leave people in their conflict, then they're ultimately going to sell the land in a moment of frustration, right? I'd also say that in response to Let's Talk More Action, this platform is really important, but there's another one as well that the department is also responsible for, and the DDG Ndove is actually mandated by the minister. That is the multi-stakeholder platform. We launched this during lockdown when we couldn't meet and gather. But since then, we haven't had opportunities. So as civil society, as Chapter 9, let's go back to that. If we had days and days of these conversations, we would surely come toward implementation. To answer you, Tim, absolutely. Amending the Constitution is the hunger and frustration people feel. But the reality is, let's implement. Let us implement what is in front of us right now. I'll hand over to others.
In terms of amending, yes, the Constitution, or especially Section 25, can be amended. But in most cases, those amendments, sometimes when we do challenge them as the communities, the Constitutional Court finds that they are unconstitutional and invalid. So it's better for us to go straight to the Constitution without dealing with the amendments, because we'll be like going back and forth and on. So if we're saying we discredit the whole Section 25, I think that will work for the communities.
Okay, can you please stand because they're screaming
Sorry. So in terms of what is the CSOs doing to, for example, to deal with conflict, I gave some examples where, for example, they are mapping land rights and registering. So there is some form of adjudication because most of conflicts are around boundaries, around claims. But also, I gave you those examples of the work that has been done by AFRA and the work that colleagues at SWAP are doing. So in terms of going further with that, there is work around institutionalizing some of these interventions. The challenge is to get the government to then adopt them and upscale them because they've already been proven to work. But the challenge, again, the ball goes back to your court, Commissioner. Thank you.
Thank you so much, colleagues. I just want to say thank you to Gaino, Siabonga, and Tsepo for wonderful inputs and continue the hard work that you're doing. Sometimes not pleasant, at times confrontation, all of those things, but you are the conscience. Thank you so much. I now hand over to the program director.
Commissioner, we have gift packs that we normally give to our to our speakers. We also hope that, yeah, even in the earlier session we did that, and we also made a disclaimer that these are just gift packs. There is no conflict of interest associated with this in the Human Rights Commission. So please do go ahead. Yes, yeah, the morning session. If we have those presenters, can we please have them come up stage and get a token of appreciation? We are about to go for a 10-minute stretch, but of course there remains there tends to be a remainder of some murky issues around, perceptions that are associated with structures, governance structures. And it has been brought to my attention by one of our traditional authorities that he would like at least 2 minutes to to clarify some of the problematic perceptions that they wouldn't like to leave this room without clarifying. Nkosi Zolile, let me give you just 2 minutes before we go for a break.
No, it's just a small matter, ne? Just a small matter. The institution of traditional leadership is not an institution of saints. It's very important to understand this, but it represents the foundations of our society. It's very important. One person here spoke about colonization of a special type. He did not take it to the logical conclusion to say we are a republic of a special type because we have the institution of traditional leadership recognized by the Constitution. Number 3, the apartheid state, including coloniality, in order for it to find some little legitimacy in some spaces of our society, they co-opted some of the traditional leaders and they used them to beautify the apartheid system. We know that. We are actually founded on the basis of counteracting those traditional leaders who were used against their own people. Now, in the new South Africa, it goes without saying that there are bad apples in the system. People who will act out of character. People who will act out of our own values of Ubuntu and do things that are outside the framework of traditional leadership and how it ought to operate. But please, don't paint the institution with the same brush. That's not what the institution ought to represent. It's a distortion. I think Prince Namashe explained it here, that we are a people's institutions. And we don't have subjects in Africa. We have people, Khosi ki khosi ka batho, inkosi inkosi ngabantu. That means that the power is with the people. Like I said, traditional leaders are only there to ensure that what people decide on gets implemented. They rubber stamp it. Thank you very much.
Zolile, we can just take a 10-minute break because when we return, we will get a summary of some of the inputs that have been made by the various presenters, by the various individuals who also had questions and made inputs from the floor, so that we can get to summarize the real reason why we are here and what we would like us to see moving forward when it comes to attending Section 25 from the Constitution. So we can go and get a break, stretch 10 minutes, and then we come back. Thank you.
I will tell her. Oh, I thought they were buying
Human Rights Commission. So that's protector mayelana nomhlaba. So silana singelenile njengetalana. So sodlula inkinga tenu ukuthi labanye mhlambe bane-claim, i-claim yabo sola iphumeleli. Ngiyathemba ukuthi sitawuphuma ne-answer ngoba bayasithembisa ukuthi ugovernment uyibukile le nto yokuthi umhlaba kufanele uye kubantu. So manje-ke ahlali basempumalanga nathi-ke ukuthi-ke into yenze kuhamba kahle labo bane-claim, abanye ama-claim abo ba-claima kodwa baphethe itifiketi. So lo tifiketi labo abawutholi umhlaba. So kweneka ukuthi namuhla batawugcina bawutholile umhlaba wabo, batawuva kahle ukuthi kuhamba njani. Sihambe nobaba President Mkwena, sahamba noSithandeka, sitelana sibone bonke bo-public protector. So into le ngijabulisa ukuthi into lekhulunywa ukuthi masifika la bakhuluma ngalo mhlaba lokuthi umuntu lophethe isitifiketi kufanele asithole ngoba akukwazi ukuthi kungazuza abanye abantu abangazi bawulwele umhlaba. Manje nathi silana nje silwela umhlaba. So manje bahlali basempumalanga, Mpumalanga, Gauteng yonke nathi ukuthi sitonilwela la ukuthi ku-Human Rights Commission ukuthi manje nikhone nani ukuthi maniphethe itifiketi enu ningathuli, nitawuthola umhlaba. Siyabonga kakhulu. Thank you very much for everyone. Siyabonga kakhulu.
Let's miss together, see
Talks.
So
you see how it goes very well.
Once he has done
Welcome back, colleagues. We are now ready to proceed, but before I call the CEO to come on the stage to give us a way forward and summarize all the discussions that have happened today, we did have some online comments that we had missed because we were streaming live, and I thought just before we actually proceed, we should just capture the 3 comments that came online in order for us not to be exclusionary in our mode of operation today. So the first comment was coming from Malatelo Mohale, and she said that traditional leadership should never own land. They have proved to be undemocratic and unconstitutional in many ways. For example, there have been abuse, violence, and pushing these issues to be addressed, even in public spaces. And then Kabelo Edward Masanemela said that, I hope the Deputy President is serious about dealing with tenure security. Hopefully he is not campaigning. And the the third comment was from Kenneth, and he says that the problem lies between Section 25 and Section 26. There's some hierarchy between those two who own properties and those who are landless. For example, occupiers, equitable access cannot mean a balance between the haves and the have-nots. So those were the 3 comments that we got online, and we are noting those comments. So without wasting any further time, let me call the CEO, Kabazela, to come up and just share the inputs that have been summarized and give us a way forward. Thank you.
I'm wondering if this is an indication that one day I will be Kabazela. Because just to correct one thing, the arrangement was that our CEO, Mr. Vusmuzi Mkhize, would do the summation and way forward for us, but he has unfortunately taken ill today, so I'm stepping in to assist the process. My name is Eric Mokonyama. You'd note on the program that I was to do the vote of thanks, so we have swapped roles. I'm doing the summation and the way forward, and Commissioner Jonas Banyoni would deliver the vote of thanks for all of us. So good afternoon, everyone. Let me acknowledge and appreciate the presence of all executives who are here, officials from different offices and institutions, the program director, the commissioners of the Human Rights Commission, and Chairperson Majola in his absence. Mine is a very easy task. I'm just telling you what you have already heard. Perhaps some of you were not here yesterday, so that will assist in giving all of you a sense of the deliberations from yesterday until today. So we opened our conference yesterday morning with, which was day 1 of our conference, with the welcoming remarks from the chairperson of the Human Rights Commission, Advocate Bongani Majola, who reminded all of us of the purpose of the informed and or reminded all of us of the purpose of the conference, being the marking of the 110 years since coming into effect of the Native Land Act. He indicated that the main objective really is for all of us to reflect on progress made, if any, on the purpose and fulfillment of Section 25(7) of the Constitution. He noted that the Human Rights Commission has done a lot of work in terms of the land question, but highlighted the magnitude of the challenge still confronting us in terms of ensuring that we have a concerted action amongst all stakeholders of ensuring that this question is addressed, especially by Chapter 9 institutions. His opening remarks were followed by a moving poem which was recited by Commissioner Jonas Sibanyoni, by the poet Thomas Mzwenduku Masuku, called Ukhalelani Nkonyane Kandaba. The poem was a lamentation on the dispossession of land dispossession of black people of the land. Then that was followed by our first plenary, which was a conversation unpacking Section 25 of the Constitution. It was moderated or facilitated by Commissioner Philile Ntuli. It answered or discussed mainly three questions. One being what South Africa can learn from other countries in respect of land reform. Secondly, struggles in terms of legal, social, and political activism. Thirdly, what do Chapter 9 bodies and other institutions created to advance constitutional democracy in respect of land need to do to ensure that the land question is effectively addressed? Commissioner Ntuli noted broadly that the Commission is tasked by the Constitution to act independently without bias, and that the Commission views civil society organizations as a key pillar since they play a role in checking and monitoring the state. In that plenary, we had a number of presenters. It was Mrs. Chanel van der Berg. She wanted me not to call her doctor. I don't know why. I know her as Dr. Chanel van der Berg. She works for the Office of the United Nations High Commissioner for Human Rights. She gave us a broad picture of the constitutional provisions in relation to the issue of land, contrasted that with the international instruments which recognize that land is a prerequisite for enjoyment of various human rights, that all rights are indivisible and interrelated. She impressed on the importance of the need to ensure that the issue of the land question caters for vulnerable groups such as women, and look also into the effects of climate change in terms of the whole discussion around land. Further, that instruments or processes such as the Universal Periodic Review could be a critical cornerstone in terms of which recommendations that emanated from that process can really guide the country in terms of dealing with this question. Mrs. Mpho Rabueni from Ndifunu Ukwazi also presented, touched on the lack of urban land reform as a challenge and pointed the need for a conversation around this in light of the rapid pace of urbanization. She indicated or impressed on the importance of ensuring that we achieve equitable justice in terms of land and ensure that tenure is secured towards building a more just city. She shared the experience in terms of lack of political will and the entrenchment of financial interest, which conflate the efforts of the country to address the land question. She called on an examination or presented on the examination of Section 25, which they have done, which looked at the gaps in the law and made a call that government should ensure that land is released to ordinary people. That was followed by a presentation by Mrs. Nolondi Luwaya from the Land and Accountability Research Center, who flighted slides that showed the land distribution in the country. Those of you who were here would recall those maps, which were really worrying, in terms of the picture they painted. She highlighted that the patterns of land distribution also showed the patterns of inequality. She cautioned the need to be mindful of the limitations of the law as an instrument of redress. She pleaded with the Commission to be vehement and to advocate for those who have been dispossessed, called for the voices of the poor and the dispossessed should be continually heard, particularly in the context where the principles of public participation are not being adhered to. She called for the Interim Protection of Informal Land Rights Act 31 of 1996, commonly known as a PILRA, to be made a permanent law. I recall how the Deputy Minister impressed on how this can never be permanent, but I think the context is understood in terms of the need to make sure that this protection stops from being interim and it becomes a permanent tool for the benefit of beneficiaries. She emphasized that this piece of legislation, if it becomes permanent, should be bolstered by regulations. Her presentation was followed by Mrs. Carmen Lowe McKay from Women on Farms project. You could tell from the passion with which she was presenting that she was from Cape Town, or she is from Cape Town. She emphasized or presented on the fact that women are most affected by lack of access to land, and that they need to really benefit from land reform because they are the least beneficiaries thereof. She lamented the plight of seasonal women workers, especially in the context of South Africa having a progressive constitution. Further lamented the slow pace of land reform despite the progressive land or progressive laws. She stated that despite international norms and standards which South Africa is party to, nothing much has been done to address the land issue. She called on the Commission to support people driven by agrarian land reform. We then moved to plenary 2, which unpacked the work of relevant institutions that deal with issues of land. The plenary looked into 3 issues. the challenges that government is facing when it comes to implementing these recommendations which come out of different relevant institutions pertaining to the land issue. Secondly, the role of corruption in non-fulfillment of those recommendations. Lastly, assistance which government needs from civil society and Chapter 9 institutions to address the land question. It was facilitated by our Deputy Chairperson, Ms. Fatima Chauhan. We had presenters, Mr. Teris Ndove, the Deputy Director General responsible for land redistribution and tenure reform at the Department of Agriculture, Land Reform and Rural Development. He highlighted the impact the Native Land Act has had in terms of the challenges, the triple challenges of unemployment, inequality and poverty. Stated that South Africa has two distinct tenure systems which relate to secured tenure system and the other being insecure tenure system. He informed the conference that a land audit that had been undertaken about that land audit, and he presented statistics on the land ownership in South Africa, which is along racial lines, revealing that 72% of the land was still owned by white people in the country. He informed the meeting that the Presidential Advisory Panel on Land Reform had made some recommendations, including that certain groups needed to receive greater and special attention on land issues, for example, women, youth, and persons with disabilities. I must say I noted in the presentation by the Deputy Director General that like in many other spheres in terms of government programs, government has or is still on zero in relation to ensuring the or ensuring that people with disabilities benefit from the land reform program. They have serious challenges on the employment side, but this is also another area where we see people with disabilities being very much disadvantaged. We then had a presentation from Mr. Cameron Jacobs, Chief Director from the Public Service Commission of South Africa. I must tell everyone that listening to Cameron, I was just listening to the Human Rights Commission because he used to be with us, so they poached him from us. We will get him back, DC. He touched on the challenges faced by the country in terms of failure or our failure in implementing policies. His view is that Section 25 is not a problem, but rather the underestimation of the magnitude by government of what the whole land reform program required seems to be the problem. In his view, there's a need for proper capacitation of the Commission on Restitution of Land Rights so that it is able to do its work. Further, that the willing buyer, willing seller policy seems to not consider provisions allowing for expropriation. He concluded by impressing on a challenge which is being presented by the silo approach, which seems to be coming up from different relevant stakeholders around the land question when we try to address this. And in his view, or in his assessment, that silo mentality is really, pulling us or drawing us back tremendously. His presentation was followed by a presentation from Mrs. Nomfundo Ntloko Koboto, the Chief Land Claims Commissioner from the Commission on Restitution of Land Rights, who stated that 3.8 million hectares had been acquired thus far or has been acquired this far, and that about 53 billion rand has been spent in respect of that acquisition. The budget to address land issue was insufficient, and chances are that it would not be increased. She indicated that 6,000 matters that still need to be settled from all claims may require 30 years if no extra funds are allocated. On the question of Section 25, she stated that the law dictates that the Commission expropriate with compensation, and that they are guided by legislation such as PAJA, the Expropriation Act of 1975, and that the Expropriation Act references market value as the basis, not just an equitable compensation. This, in her view, this hamstrings the ability to expropriate land. She called for a closer working relationship between C9s are Chapter 9 institutions, civil society organizations, and government as a whole. We then had got into a questions and answer session. Questions were posed by the audience, including, amongst others, international law, agenda on land reform, focus on land reform, which seems to be rural-based, and that there is demand in urban areas. And lastly, whether an audit on how land was acquired by current owners had been conducted. There were responses to all these questions. I may not have time to go into each and every one of them because of time constraints. We took lunch. When we came back from lunch, we were addressed by the former Minister of Public Service and Administration and member of the UN Committee of Experts on Public Administration, Mrs. Geraldine Fraser-Moleketi, and she explored 3 points. One, has South Africa reckoned with the Native Land Act? 2, whether the country need a reimagination of Section 25, especially Section 25, subsection 7. Lastly, what does reimagination look like? Which I found to be very important or powerful points of exploration. She highlighted the challenges that continue to be posed by land dispossession, particularly poverty, inequality, and unemployment. Also the need to take measures to deal with land dispossession following the dawn of democracy. Also that the efforts have been met with, a number of an amount of success. However, she indicated that the promulgation of legislation such as ESTA, the Labour Tenants Act, as part of fostering security of China, has been very helpful. She noted that there are arguments that the Communal Land Act has failed due to issues such as willing buyer, willing seller principles. She articulated the role of the Human Rights Commission in land reform and informed the meeting that the Commission has and continues to monitor public land use through investigative hearings, that the Commission findings point to lackluster state response to land reform, and she was really concerned about the pace in terms of the response by the state in implementing land reform. She highlighted the Kgalema Motlanthe report, noting that the report addressed poverty, unemployment, and inequality, and found that the pace of land reform is slow and drift away from a pro-poor approach. It recommended a range of high-level and legislative reform, such as a need to adopt new legislation to address land reform with a focus on pro-poor, since the current one was marred with elite capture. She zoned into whether the constitution needs to be amended. She noted that the Kgalema Motlanthe report stated that government has not used the constitutional provisions, thus rather recommend constitutional amendment government, or rather than recommending constitutional amendment, government must use its powers of expropriation as given in the constitution. And I think this is an idea or a view which was shared by many other attendees of this conference. She, on the issue of land, she raised questions such as, have we diagnosed the issue around land reform? Will the amendment of the constitution address the land question, and will that be necessary? Or is that necessary? Does the state need an overarching legal framework? Does the state have the capacity to attend to legal reform? Is there sufficient political will to ensure land reform? I can tell now, just out of going through the summary so far, that you can hear from a number of presenters from yesterday that there are a number of commonalities around, is there a need? Have we used the current legal framework and the constitutional provisions sufficiently? Do we need a new law, or do we just need to make sure that we apply what we have? Do we have the necessary resources and capacity to even apply the current law? She asked, importantly, having been a politician in the country, whether there's sufficient political will to ensure land reform. How do or whether giving agency or whether the issue of land reform is as urgent as communities are bringing this up, through different structures. What does equitable access really mean? How do we fast track equitable land reform as a catalyst for sustainable development? How do we prevent corruption around land? How do we move from rhetoric to action? Again, pointed questions which really came up through yesterday and to some extent during the course of today. She asked how we shift from political rhetoric to action. She asked the audience to hold the imaginary of Solplaki alive and called on the conference to be a landmark event to set South Africa on the road to equality and justice for all. We got to our last plenary, which was not that long, which presented the work of Chapter 9 institutions on land, facilitated by Commissioner Andregam. We listened to presenters, Commissioner Jonas Banyoni, who highlighted the work of the Commission, the challenges we are encountering now around our powers, and the binding effect of our directives and recommendations, and indicated that we are even in the Supreme Court of Appeal in terms of ensuring that our mandate and our powers are protected, because we have had courts who have already cast some doubt on the powers of the Human Rights Commission. We cannot afford a situation as a Chapter 9 institution where we are rendered toothless by the judiciary, particularly if that is informed, in our view, by some level of misinterpretation of what is contained in legislation. For the court to have made a conclusion that because in the Constitution the public protector is mentioned first, followed by the Human Rights Commission, followed by other Chapter 9 institutions, that means that the one which is mentioned first has superior powers to others which follow, just does not make any. And Commissioner Sibanyoni yesterday said you did not need to be a lawyer to, appreciate that there is a challenge with that kind of interpretation. He, Commissioner Sibanyoni, called on other relevant stakeholders and CSOs to support the Human Rights Commission in the quest or in its quest to ensure that its reports are implemented and do not gather dust by any means or form. His presentation was followed by a presentation from Dr. Tembinkosi Twala from the Commission for Gender Equality, head of research there. He highlighted the importance of land reform and how it directly impacts on equality. Gave an example that at the moment, in their view, it will take many years to achieve gender equality if action is not taken, and we only end with conferences and talks. He mentioned that there are concerns that lack of urgent land reform can affect areas such as gender equality. Emphasized that there is now a need to move towards implementation of policies of land reform, as the delay will have severe consequences. He highlighted the victimization of women, particularly in customary settings. Lastly, last but not least, we had a presentation from the from Advocate Koleka Taleka. Yesterday, we had a very academic engagement as we were breaking for tea with someone saying acting public protector, and someone else saying, no, she's no more acting public protector, she is public protector. The writing is on the wall anyway, if not yet. She stated that government has not done enough to address historical legacy of land dispossession, and that it has not used the laws at its disposal to address the land question. Issues of corruption and lack of policy implementations need to be looked at. Furthermore, that corruption was affecting land reform, and changing laws on its own will not address the problem. Then her presentation was followed by Professor Msoma, who is still with us here's presentation. Listening to Professor Msoma throughout the conference, I was wondering or saying to myself, Professor Msoma could be a good pastor. Pastors, to some extent, are expected to make their listeners, their followers, to believe. So he has got that skill, in my view. So he called on us on the importance for looking into a belief system as it has contributed, or how where we are is informed by a belief system. In his view, access to land is important even for cultural activities such as burials, memorials, and access to graves. He says land is important for social cohesion, and he calls on the implementation of policies as being at the center stage of ensuring that we need or ensuring that we move away from talking and talking and talking and talking. If we do believe, then we must act, because what else? We can believe forever, But if we do not act out of our belief system, we will never get anything out of it. We then got a presentation from Ms. Habo Kopani from the Auditor General, very energetic. I must say, whilst I had been listening to every presenter, when she stepped up, because of the strength in her voice, you couldn't concentrate on anything else than just to listen to what she was saying. Stated the importance of the need for public sector behavior change, so that we are all focused on people, and make sure that the land question in South Africa is answered and addressed. She indicated that AXA reports, or talked about AXA reports that provide information on performance, and that we must have an ecosystem so that we have complementarity and use the findings in the AG's reports to attend to certain matters that are identified. And she emphasized that entities need not work in silos, otherwise they cannot achieve much. And I think the importance of her presentation was that we cannot afford to see any of us as an individual entity. Look at the Commission on Land Rights as them who must sort this mess out, or government, the department as them who must sort this thing out. All of us have a role to play, and it is only if we complement each other that we'll be able to achieve our objectives in terms of addressing the land question. Again, there was a question and answer section, which I will not go into. There was just one important aspect out of those questions and answers section, which basically, drilled down to what is delaying government to distributing the land that it owns. And someone asked earlier today in Xhosa, and he pointed the question to the Deputy Minister, Silindabani. Who are we waiting for, to really get land into its rightful owners? Day one was concluded. We came in this morning to go into plenary 4 around traditional councils and traditional leadership on challenges experienced by these structures in addressing the land question. The plenary was facilitated by Commissioner Angie Makwetla. We firstly listened to the program director, Dr. Tina Nzo, summarizing the session and indicating that lots of issues arose in the session, including whether South Africa is a rupture state. Her remarks were followed by a presentation from Honorable Prince Zolile Benz Ngamashe, Deputy Minister, Department of Corporate Governance and Traditional Affairs. His was followed by Zolani Mkiva. I think this was the other way around. I may have confused the sequence. Mr. Mkiva indicated that there was a need for land that is owned by the state to be placed with traditional leaders as custodian. Women, youth, and poor people in South Africa should be able to be considered as beneficiaries, as the law should reflect our lived realities. We also had Mrs. Samantungwa Mbeki, the Commission's provincial manager in Gauteng. I'm not going to go into the details of everyone's presentation, especially in relation to today's plenaries, because I take it their presentations are still fresh in your heads. I went into detail in terms of yesterday's ones because some of you may have not been here, or we obviously, had a night in between. We might have forgotten some of the issues which were raised. We then got to plenary number 5, which touched on civil society organizations and non-governmental organizations, facilitated by Commissioner Nissen. We got a presentation from Mr. Siabonga Mahlangu from Inner City Federation, who spoke to the impact of the land question or issues on ordinary people. That there are laws and there are structures and all that, but the ordinary man on the street or on the ground is impacted more, and there's a need for all forces to really prioritize and ensure that the structures put in place to address this question is meaningful not only to the rich but also to the poor. We then got a presentation from Dr. Genor Paraza from Public Affairs Research Institute, who gave us few examples of the kind of work they are doing, emphasized on the need for people to understand each other and not to speak past each other, just in terms of relevant stakeholders in the or in addressing the land question. Also, the need to engage with one another and not only interact during protests. Also, that there's a need to move away from legalizing things and making the process easier, but making the process easier in terms of addressing norms or using norms, standards, and values. Lastly, that there is a need to integrate land reform so that one approach is not superior to others, and that will reduce bottlenecks. She completed by indicating that the land issue is one of those issues that South Africa needs to look at as one state instead of different role players. Mrs. Tsepo Fokani from Land Access Movement of South Africa highlighted challenges that are faced by rural and urban or people in rural and urban areas which needed to be looked into, that there's a need to put infrastructure on land reform so that people can settle properly, need to also register land properly so that it is easier to navigate. She touched on a number of examples which really highlighted the realities of the complexity of the implementation of the land reform program in the country. Now, that closed all the plenaries for this conference. Just painted a picture. We need to look into a way forward. I'm going to request and almost impose on the session to look at the way forward differently. I am used to instances where a presenter will come up stage and tell everyone the way forward. The Commission does not have a way forward. This session must look into what we have captured as points or pointers which came out of the conference and indicate if and confirm if this is what we agree is the way forward. Professor Msoma will kill all of us, I imagine, if we walk out of here or he meets us in a year, 10 years' time, and would have not come out of this conference with an action plan which highlights what is to be done from here, and hopefully with some time frames so that that talk ends and there is some activity-oriented intervention which will inform our approach going forward in terms of addressing the land question. I have the following pointers. One, we noted from the deliberations that the continued existence of numerous players is affecting realization of results. Therefore, a closer working relationship between Chapter 9 institutions, civil society organizations, and government departments should be established and encouraged. We should work out how, if this is what we agree is one of the steps we're going to take following this conference. Secondly, we need joined hands aimed at supporting initiatives which are focused on furthering the Constitution. I did not hear from any of the presenters or participants calling for the doing away with the Constitution. So, and many people touched on the importance of ensuring that when you have legislation, you use it. You can't afford to have legislation, and if it doesn't work, you throw it into the dustbin, and you come up with another legislation. If it doesn't work, you throw it. You must find out what is wrong with the one you have by using it. And where you identify gaps, address those gaps. So we are proposing develop a matrix so that each Chapter 9 has a role to play, and the AG report and findings can help us to provide a base for areas that need attention, so that work is people focused. It is not just this institution sitting, coming up with some document or plan saying this is what needs to be done. It should be that we put together that matrix, but the AG, because they look at everyone else in terms of what we do, assist us in availing the reports and findings for us to use that as a base and make sure that whatever action we're taking informs the needs of the people, not our feelings or our preferences or our aspirations as Chapter 9 institutions. Thirdly, and this speaks in a way to the two first pointers, collaboration. We must always remember Chapter 9 institutions are oversight entities and not implementers. And by that we mean, very often we get communities coming to our office saying, we want water, we want IDs. I always say to them, I wish the Commission had ID printing machines, because maybe we would just print and then you go away, you have your ID. Unfortunately, we are oversight entities. We need to make sure that we make our mandates very clear to South Africans. And we also make very clear to South Africans the role of government. I always say to such as this that, the Constitution, especially the Bill of Rights, is structured in such a way that you are able to connect every department to a right in the Bill of Rights. So, whilst we are oversight bodies, we should be able to direct society to say, you see, you have a right to education. we have the Department of Education. We have the right to land. We have the Department on Land. We have the right to health. We have the Department of Health. So the importance of all of us in society understanding the roles and mandates of each and every entity we have in the country is very critical. Moving on, we must examine and understand the obligations and recommendations set by international law. Most of legislation we have in the country is informed by international law. We are signatories to those international instruments. We must always make that connection and ensure that we follow on the implementation of domestic legislation or domestic legislation which is connected to international law, because we have obligations in that respect. We must provide easy to understand data on the actual land reform. I have listened to many people here. I can tell you, even at this stage, I'm not sure that there's a common understanding between all these concepts: land reform, land redistribution, etc. So unless and until we understand these concepts and we understand whose role or what part of all this project is whose role, and before and unless we understand that, we are going to keep on chasing the Commission on Land instead of chasing the department, or chasing the Human Rights Commission instead of chasing the department. So that is very critical to understand data on the actual land reform and those roles I've touched on. Information should be availed in a comparative and disaggregated manner on all our sites so that we can easily see the progress over time much more easily. Core to this conference is to look at Section 25, look at where we are since our constitutional democracy in terms of achieving land reform, and where we want to go. We cannot make that determination if we do not have and understand data which gives us an indication of progress we have made over time to this point. Land reform should not be viewed as ending when an individual gets land. This was emphasized by a number of people, because at some level we're thinking one day if we wake up and we are given a hectare of land, that will solve our inequality, unemployment, and poverty challenges. There needs to be a program, a holistic program which addresses the challenge we're having currently with landlessness. We should encourage post-settlement support to beneficiaries of land reform. Make a call on government to avail land under its control for land reform. Ensure that legislation such as the PILRA is made to protect beneficiaries, not in the interim, because we're not living in the interim. So there needs to be legislation in place to make sure that the protection is eternal. Lastly, we need to agree on an action plan and urge everyone to move from this rhetoric of talking to an action plan. So these pointers which I've just highlighted to everyone should guide us on what do we do from here. Obviously there will be a report out of the conference, but does this capture the outcomes of the discussions? And that, is this enough for us to then work out an action plan out of this towards ensuring that the outcomes of the conference are implemented? I know we don't have time. Someone just said we. Come closer to me and finish. I'm not going to act like a judge. Can I check out of all of us whether this captures the deliberations? There's going to be a report out of this conference, which will also in terms of the pointed actions, because Professor Musoma, we agree there needs to be action. I think maybe for me what may just be lacking out of it, or this summary, are time frames. But out of this, I think we can take out what needs to be done in a pointed way in terms of actions. I can take only 3 hands. Okay. Okay. Maybe not even that. I want to propose something else. Because of the time constraints we are facing, we could share this with everyone and invite if there could be additions to these pointers, that they be shared with the Commission in writing so that we can then factor them into the report. I think if we adopt that approach, that will enable us to end the session now and go and eat, because one thing Chairperson will kill me for is if we infringe on people's right to food, being the Human Rights Commission. So, Commissioner Spanioni, I know you can still run. Maybe make your way to me as we leave. No, Commissioner Spanioni, you can no longer run. I was expecting that you'll be here by now. I want us to make our way to have lunch, otherwise they are closing out on us and all of you will kill me. So I want Commissioner Spanioni just to thank all of us as we take our packs and move to the lunch area. Thank you everyone.
Thank you very much, Mr. Mukonyama. I will be very brief, I will be economic. I've made some copious points as to who and who to thank, but in view of the time, I will not go into the copious notes that I've made. But I want to thank you, Program Director, first of all, for conducting this conference so well, Dr. Tinanzo. And then secondly, I want to thank also Commissioner Nissen as well as Commissioner Ntuli, who joined my focus area because this conference was settled in my focus area as the commissioner who is leading the focus area on land, farming communities as well as an environment. But it will be amiss if I don't also thank all the other commissioners, because we did not work as in silos, and they also joined hands together with their RA. RAs means research assistants, as well as their PAs, the professional assistants. I want to also
thank Advocom, Advocacy in Communication, because they came on board. I want to mention their names to save time. But I will also thank Research, because Research also came on board. The CEO, Vusim Kize, who's unfortunately not here, I want to thank him in absentia. I want to thank you, Mr. Mkonyama, once more, that you were a teacher to me when I came to the commission. Planning meetings were held in preparing for this conference, which people regard as a landmark. And then we worked, that was a teamwork in the true sense of the word. And then I also want to thank the participants, because without the speakers, without the stakeholders, this conference would not have been a success. And then I will also want to thank the people who joined online, and then also to thank the media, TV and the radio, who were interviewing me. And then in conclusion, I want to say it's a dream in fruition, and then also to end with the words of Tata Nelson Mandela, international icon, who said, "It is in your hands now." They've played their role, Tata Mandela. They've played their role, Abo Robert Subukwe, Abo Sol Plaatje, and the other forebears. It is in our hands now. Thank you.
This one is for a special guest of ours in this conference. Commissioner, if you could hand this to our program director. She has done sterlingly well, pro bono, with a smile from the first minute to now. Thank you so much.
I said she acted as if she was a radio presenter, the way she was handled. Thank you so much. Let me do this. Tata Nelson Mandela used to do this, and hug you like this, and then the left cheek like this. Thank you so much.
Thank you, everyone. Lunch is served.